order whereby Order 7 Rule 10 application has been rejected.
Why so urgent today?
The urgency is, my lord, on the time of mention was, if I indicate to my lord, but there's a judgment of the Honorable Justice Krishna Rao, which has, my lord, referred this issue, whether it will be a commercial dispute or not, to the larger bench. But there was a judgment by the Honorable Justice Sabashachi.
What is so urgent about
the urgency is this, my lord, that if the suit proceeds, at the first time, the suit was filed before the Barasat court. Then it was transferred to the commercial court, stating that it's a commercial dispute. We filed an application, Order 7 Rule 10, that it is not a commercial dispute because this relates to a lease agreement which expired, and at the time of filing of the suit, the property was not being exploited as a commercial dispute, as well as the agreement stood expired by efflux of time.
You take that point before the court, commercial court.
Well, you have taken this point, Order 7 Rule 10. That has been rejected. That is the impugned order.
Very well. No, what is so urgent about it?
No, the urgency is, Lord, today the suit
Order 7 Rule 10.
Rule 10.
Very well.
Lord, at this point of time, Lord, if the suit proceeds,
yes,
and the larger bench decides negative,
Lord, yes, everything will stay then.
Lord, my only prayer is before my Lord, can you stage the?
I will pass an order rejecting your prayer.
No,
absolutely, sir. There is no prayer, no order. I'll reject. I'm very clear. The parties must be conscious and aware where they stand. So I'll make it clear for you.
But kindly, can you text up the impugned order once?
Why? How can I today? Today, it's an Order 7 Rule 10 application. The court has rejected. What is so urgent? First of all, the matters are pending, sir. So many matters. So urgent about your case that I'll take it up today.
The urgency is, this relates to, this is a leave and license agreement by the Airports Authority of India.
Yes.
The business was going on. They have raised a point regarding recovery of money.
Correct.
Today, the suit proceeds, and the larger bench decides that this will not be a commercial.
The consequence will follow. The consequence will follow. Please understand. The consequence will follow. What happens? It no longer takes the character of a commercial suit.
My lord.
For that, the object of the Commercial Courts Act will stand frustrated. If I stay the commercial suit because a larger bank is pending here, what are you saying? The commercial, please understand.
My lord.
The commercial court has dismissed your application. Please understand. There is a challenge to that. This court, according to you, cannot decide this issue. According to you, cannot decide this issue.
This court can. My lord.
No, because the matter is pending before the larger bank. You just indicate.
No, but I'll indicate.
That is your contention.
No, but I'll indicate. My lord can definitely adjudicate.
What is the stage of the commercial suit?
But the commercial suit, I think case management hearing.
Let it go on. Have the larger issue. Yes, madam.
Your Lordship, this is not at all a commercial suit, because the ingredients of a commercial suit under Section 2, defined under the Commercial Courts Act.
The matter was transferred to the commercial
court. Suo moto, not on anybody's application.
Did you challenge that order?
Your Lordship, that order has
did you challenge that order?
Your Lordship.
Where did you challenge that order?
This petition, Your Lordship.
This petition?
Yes, Your Lordship.
But in the interregnum, you filed an Order 7 Rule 10. So
for transfer of the case before
No. Yeah, so
that was rejected.
Transfer order. Transferred that order.
Huh?
Who transferred that order?
Suo moto, the court.
Barasat has transferred, my lord.
I understand, man. Sir, please wait, sir. He's as it is finding it difficult. You don't add anything. Kindly take your seat, sir. Kindly take your seat. Madam, there is an order passed by the court directing a transfer.
Your Lordship.
Is there any challenge to that order?
Your Lordship.
Where is that challenge?
Your Lordship, in this proceedings, we have challenged that order as well, stating that the court could not have transferred.
Very well. I understand. These proceedings you have challenged. Now, tell me something. Did you apply before the commercial court under Order 7 Rule 10?
Your Lordship.
Then how is your challenge, subsequent challenge, maintainable now? You cannot turn the clock back.
That's what was my prayer, that this suit is not a commercial suit at all, as there has to be a written agreement, Your Lordship. The basic
matter is going on before the commercial court. I'll hear your matter. Commercial suits, I give precedence. I will hear. I'll not as an urgent motion matter. This is not an urgent motion matter.
Your Lordship,
you tell me this is an urgent motion, madam, and this.
There's a time frame within which it has to proceed.
Yes. Let it go. Court management proceeding is going on.
Your Lordship, that entire application would be frustrated, Your Lordship.
Which application?
Application for under
Your
order.
application under Order 7 Rules 10 has been rejected already.
Your Lordship, with the order is not reasoned order. What had happened, Your Lordship, this is my second application.
Whatever,
First
it is reasoned
application,
or not.
Lordship,
This
Your
forms subject matter of challenge here.
Your Lordship, allow me 1 minute.
Yes, yes.
First application was filed, same application.
I'll place it as returnable motion and here, not as a motion, not as a motion. I will not grant any stay in these commercial suits. I am not granting stay in any of the matters. The other matter also I disposed of, where the issue came up with regard to whether a
But Your Lordship
counterclaim
fixes a time
is required. Yeah,
When
I'll
Your Lordship-
not fix a time. I'll place it under the heading returnable motion. I'll take it.
at the top.
Yeah, this has
Returnable.
been done long back.
Your Lordship,
Yes, Alam, he has retired. He has been transferred now.
Your Lordship,
He is
there
no
was-
longer there.
that was the first order. That
Yes.
was challenged. That was
Order 7 to
returned.
10,
Your Lordship, that was renewed.
2024.
Your Lordship,
After 1 year you have come.
no, Your Lordship, I came immediately.
Next date is 4.
February. So there is no stay.
Your Lordship,
Matter has continued without any stay.
Your Lordship,
I
because
cannot
Your
grant any
Lordship,
stay today.
on the first day, the court wanted to know the recent judgments. We had filed a compilation of judgments.
Very well, I'll hear it out. Commercial code, I'll hear it out.
Kindly fix it.
As a returnable motion. As a returnable motion. There appears to be no,
Your Lordship, kindly fix it as just
listen to me.
If
There
you
appears to be not today. Come up, I'll take it up. I'll decide it, whichever way.
Your Lordship.
But there cannot be any urgency after 1 year. 1 year, madam, 2024.
Your Lordship,
2024, you did not succeed. January 2024.
Your Lordship,
No interim order was passed, madam.
Your Lordship. The matter was never taken up. It
Yes,
only
taken up.
Once, when Lordship asked for certain judgments, we handed over. It was made
So the
returnable.
court did not pass any order in your favor.
Your Lordship, because court wanted to be appraised regarding the judgments which were passed recently. Deepak Polymer and the next one
And-
by
Justice Krishna Rao.
Krishna Rao has been passed.
He has referred the matter to a larger bench. Very well.
All those judgments.
Now, if it is ultimately not a commercial suit, it will fail.
Your Lordship, if I disclose all my evidence, both party discloses their evidence, and thereafter it fails, nothing remains in the suit.
You will be benefited today if madam try and understand. What are you being denied? You are being denied to rely on documents, additional documents, unless you have already disclosed.
No, the
WS you have filed, has been filed.
documents filed before the trial court.
So that part is over. It only expeditious hearing, expeditious disposal, excepting for the fact limited appeal is there. Nothing more. Commercial expeditious disposal. So if the suit is ultimately decreed also, whichever way, that will only benefit to the benefit. You are the plaintiff or you are the defendant. Yeah. You are ready. Yes, your purpose of delaying the matter will stand frustrated. Okay, I'll fix it in February. It will be there. You mention it if I had not taken up.
Your Lordship, my sir.
Yes, call the next one. Yes, sir. Mr. Dole, you are playing for time.
My lord, only not today, my lord. Let it be taken up tomorrow, my lord.
If matter is taken
An
up
upgraded motion.
I do.
What is the matter?
the suit for the declaration and by practicing for only 2 page by 1 to so kindly comes page 55. This is
Mr. I'll hear you, Mr. Dole, but give me
why
let me understand the fact I'll come back.
Malad, kindly comes page 51.
Tell me, yes. So,
Malad, in the agreement for sale made in the stamp paper, malad, this is the issue. Malad, kindly see the page 51. Serial number of the stamp paper of the agreement for sale is E513576. Malad, that malad, plaintiff malad, by virtue of this agreement for sale, malad, entered an agreement with the defendant to sell the property. Now, malad, kindly see the page 55. Malad, my lord will find on the left side Baina Patro Dolil such and such, and malad, page 55, malad, the same stamp paper. Malad, serial number kindly see, and malad, this Baina Patro term has been malad, deleted, and malad, the Khos Kobala Patro has been written. I filed malad, the suit for declaration and malad, for cancellation of that deed. And in the instant and in connection with the said suit, malad, I filed an application order 26 rule 10A for malad, the scientific investigation. Malad, whether this computer printed was malad, the tampered, and malad, some communication made between the defendant and the plaintiff, that was malad, in the pen drive in mobile phone, and I prayed for malad, this that was malad, for scientific investigation to malad, the come out to come out the truth. Malad, this is on the face of the record. Malad, see the two serial number of the two stamp. That cannot be agreement for sale and sale deed.
learned judge says this is beyond the scope of the pleadings made in the plaint.
No, that pleading is there, malad. Malad, if my senior friend malad, painting for malad, not today, malad, kindly malad, take up tomorrow. 18th is a date fixed for further evidence. Malad, the learned code below, not granting any time.
You want adjournment or what do you want?
Yes. I want one day account. Yesterday, my lord, night I got the information that it is.
Why? It was not mentioned on.
No, malad, after mentioning, malad,
Not mentioned on notice.
malad, I have informed Mr. Malad, that
Just my lord,
malad, this is not malad, the not known to me when the my lord will upgrade this matter. That was malad, I informed that the any day matter can.
that
Malad,
is my lord informed.
Can't
any time
help.
the matter
Mr.
will be taken.
Bhattacharya, I can't help that. You see, I get a bunch.
Yes, malad, for that is in.
I go through and I try to understand the urgency involved
Yes.
to whatever
Yes,
extent.
His Lordship.
And
Updated matters are
Malad,
coming in the
yes,
list.
coming in the list. For
that
that,
is how I place it.
malad, for
I
that.
cannot say which date I will put.
No. For that reason, malad, I requested my learned senior friend. Kindly, malad, I shall inform. The matter will.
But this is the matter. Milord, what happened, Milord? Kindly, Milord, protects
By
in the
the
meantime.
22nd.
Milord, kindly
Malad, the
protect me
18th.
in
Malad, 18th is that malad, further evidence.
Nothing will happen.
My evidence will be closed, my lord. My plaintiff witness.
I cannot do it tomorrow. Tomorrow is Friday.
Let's go.
Then, malad,
I cannot do it tomorrow.
Then,
Tomorrow is
malad,
Friday.
I have nothing to do. The learned code below is not malad, the granting any time in spite of malad, the communication matter is appearing. So, malad,
Yes,
in
the
that,
matter is pending and they, my lord, in spite of day to day.
Don't press further on the next occasion.
so, malad,
Put on 18th, since I'll record one line. Since an accommodation, wait, sir. Since an accommodation has been sought for on behalf of the opposite parties, let this matter stand adjourned and appear under the same heading on 22nd.
and malad, kindly give malad,
Apply before the.
liberty to malad, the approach.
I have recorded this order, so this is enough.
I have a liberty to file adjournment malad, before the court.
The petitioner, the opposite party submits that it shall not oppose the prayer for an adjournment before the trial court.
Yes, yes.
What more do you want? He cannot seek an adjournment here and oppose it there.
Yes, malad,
My lord, kindly, my lord,
No, sir. If you want, if that is your intention, then I'll refuse your adjournment.
2 years, my lord, there is.
Sir, I've upgraded it right, wrong, indifferent. Now there appears to be some urgency. I'll hear it out, finish it off.
22nd.
My lord, let it remain in its position, my lord, in the top, at the top, my lord. Because my lord, 2.5 crores has been invested. And
Top.
Thereafter, my lord, I am, my lord, they have filed.
Top to what extent?
The top of it.
Above my name, I'll place it. Down. Ha.
Milord, I am for the petitioner. Milord, I am the defendant tenant. The landlord has filed a suit for my eviction under the Premises Tenancy Act. Milord, one of the grounds alleged is arrears of rent. So when I received,
Your eviction, you are the only person.
my lord, yes,
You are only defendant.
I'm the only.
6-4.
Yes, my lord. So my lord, no,
Areas of
Arrears.
on defaulter.
yes, defaulter.
And
And my lord, within 30 days of me receiving the summons,
no, defaulter and
and my lord,
ground.
the numerous, my lord, that I have changed the nature, character, all those pleadings, all grounds are there. Nonetheless, within 30 days of me receiving summons in the suit, I went and I deposited the admitted arrears for a few months.
7-1.
7-1.
And you are continuing to pay the current.
7, yes. No, and 7-1 through. Then under
No,
7.
and you are continuing to pay the
Yes,
admitted.
I am. Then, my lord, under 7-2, I made an application because out of about 10 or 11 months of arrears, I had deposited for about 5 months. The remaining period I was disputing because my contention was that I have paid before the rent controller.
Disputing the rate also.
No, my lord. Only the
On
period.
period.
On the ground, my lord, that I have been paying this before the rent controller. So I filed a 7-2 for adjudication of, my lord, the amount due. In my 7-2, I placed before the court my rent receipts, deposit proof paid before the rent controller. Now, in adjudicating my 7-2, the learned court has come to a finding that my deposits before the rent controller were bad.
Why?
Because they were delayed. They were not within the time frame as stipulated under section 21. It has to be within.
Rent controller will not accept it.
Exactly. But there was a technical problem. A new online system was coming in. So because of the difficulties in the part of everybody paying, there was a defect issue with the rent controller itself, which is why for that particular period, they were accepting belated, which is my contention that the fact that they've accepted shows that it's not my fault in paying, which is why they've accepted. Nonetheless, let's assume, my lord, that I'm wrong. Let's assume that in 7-2, the court, after it holds that there is default on my part, it has to tell me my arrears, and within 30 days, it has to give me time to deposit that money in court. And the norm is that the court will also give me liberty to take back my deposit from the rent controller, which the court hold is wrong. My lord, this opportunity is not given to me. It has been held under 7-2 that my deposits before the rent controller were delayed, and therefore 7-2 rejected. Matter kept for evidence. That's the order.
The order follows.
7, my lord, obviously, issue is not framed. Matter kept for evidence. My written statement, my lord, goes out of the window. My lord, I'm saying, kindly, this is, my lord, the order. And my lord, may I also...
Let me go through the order.
May I point out one thing before Lordship sees the order? My lord, 60 suits
I've not seen the order. I'm only hearing you. You tell me.
Very well. Kindly see, my
No,
lord.
you tell me. You tell me, and thereafter I'll go through the order.
My lord, I'm restrained in saying this, but I can't resist. 60 suits have been filed, my lord, by one landlord overnight, having a requirement of his entire property.
That he might have.
60 suits.
That he might have.
My lord, every 10-15 days, dates are being given in these 60 suits, pending before the court below. Other matters, my lord, have been taken up 2 months, 3 months, 4 months. There are matters, my lord, where dates are being given 4 months hence.
Go through the order.
Kindly see, my lord.
Place the order.
May I, my lord? This is, my lord, an order number 20, dated 10th December 2024. Learned counsel for the plaintiffs as well as for the defendant both are present. Today is the date fixed for contested hearing of application under 7-2 of the Premises Tenancy Act. It is submitted by the learned counsel for the plaintiffs that accordingly to the defendant, he has been regularly paying rent since February 2022 and depositing the same before the rent controller after the same was refused by the landlord. Rent control challenge, as has been filed by the defendant showing deposition of rent before rent controller, are all bad deposits. Kindly mark this. According to the learned counsel for the plaintiffs. The reason being the landlord refused to accept rent from the defendant sent by money order, which was returned to the defendant on 10th March 2022. The law is within 15 days of such return of money order, the tenant shall deposit rent with the rent controller. In the present case, though the money order was refused by the landlord and returned to the tenant defendant on so and so, the deposition of the rent for the month of February 2022 was made on 5th April 2022. Thereafter, for the month of March 22, it was made on 10th May 2022. For the month,
this part is all right.
yes. So, my lord,
It is really
there is a delay.
Admittedly delayed.
Yes.
This position is admitted, sir.
Yes, yes, it is. Now, my lord, next paragraph. Countering the submission, plaintiff also says
You
that it
have
had.
provided the reason. Explain this. This
Yes,
is
then
recorded.
the
here.
court, my lord, kindly see the last paragraph
Court,
now.
yes.
The court was not, should be, is not satisfied. This is
Yes.
the finding. The court was not satisfied with the explanation sought to be tendered by the learned counsel for the defendant, explaining the reason for delay in deposition of rent, as no documents were placed before this court in support of the fact that as soon as the defendant tenant received the refused money order so and so, immediately thereafter he had applied for the rent controller for depositing rent in the office of rent controller. Bereft any documentary evidence being placed before this court, submissions on air cannot be accepted by this court when the statute is very clear about the period within which tenant is required to deposit rent with the rent controller after receiving back the refused money order. Manoj, may I just stop here for a minute? I have a submission to make here. I am, of course, disputing this because if it was my fault, the rent controller wouldn't have accepted money. But let's proceed on the assumption that there was a delay on my part and the court is not satisfied and calls my deposits bad. Manoj, the court will direct me to then now deposit this arrear upon adjudication. Kindly, Manoj, see 7.2. Kindly now see the next line. In the given circumstances, this court has no other option but to reject the application under 7.2. So application stands rejected. It should have been
There is
disposed.
caveat. There is caveat.
No caveat. My friend has appeared, my lord.
There is caveat first of
No,
all.
no.
We saw the list as well.
You cannot appear unless you are directed to. This court admits it. Wait.
7.
Dispute as to the amount payment.
May I place my lord 7.2? Kindly, my lord, stays the suit. Evidence is tomorrow.
Will accept service.
Yes, well, I will accept service. Only one part, one thing, my lord. With regard to the second part of the order, dismissing his 7.2 application, the learned court, according to me, should have given them an opportunity to deport.
If you
Adjudicate
concede to that, I'll set it aside, send it back.
only that part, my lord.
No, that no.
Quantify that
The order
amount.
goes,
To quantify the
and
amount.
you see today under 7.2, under the
Given
scheme of the act, 7.1 says within the specified period you have to deposit admitted amount of rent and continues. Part C, continue. 7.2 says if there is a dispute as regards the rate or the quantum, means quantum means the period, then you apply.
With the admitted.
Yes, that is paying. Admitted, he is paying. You accept Mr. Dutt. There is no difficulty. Unless you say otherwise. Pleading say that you accept. Recording say that you accept. So therefore, today the court was obliged to decide what was due and payable. Determine, not due, determine whether there is any area. If the court comes to a finding there is an area, to give an opportunity to make payment within a particular period, which period can be extended with an outer limit. So two parts. Within a period which can be extended with an outer limit, but not beyond that. Nothing of that sort.
Only one thing. If I have understood correctly in my submission of my learned friend, because I have not got a copy.
Then
Only
I'll try to serve a copy.
Only one thing.
Serve a copy. Come back. Challenging order number 20 dated 10 December 2020. very burden. You see, court is burden. The other day I had, Mr. Dotto had called for to ascertain why the matters could not be heard. I found out. You will be astonished to hear the number of cases pending before a London judge. Astonished to hear. I'm not spelling out the figures. So there are so much burden. So I'm loath to issue directions for expeditious trials, considering this fact.
But I have a different.
This situation you have to also accept.
Sir, Dotto's client has filed 60 suits on the same
But I
day.
have a different experience altogether. I can share it with
No,
my lord.
it matters.
If the
if-
court, my lord, works, my lord, from 10:30 to this,
No,
this
you can't blame the court, sir. Everyone is working, sir.
most of the court will not.
Yes,
be
Mr. Dotto. Next, madam.
I think there is certificate copy.
Yes.
My lord, I heard your lordship goes through most of the briefs, my lord.
No, I don't go through the briefs. Absolutely no.
I thought that your lordship had seen this.
Only for upgradation to the limited extent.
My lord, here what has happened, my lord.
On a senior starts, my lord, I'm being led by Mr.
You are on caveat.
Your lordship, you are
On
on.
caveat.
Yes.
He's on caveat.
Yes. Everywhere, my lord, the question is that if a person is on caveat, does it mean that it tantamounts to an automatic?
No, I'm not granting. I'm asking. Without the caveat, I'll not hear him at all.
No, I've served.
Yes.
My
Very
lord, that is the same question, my lord. Before, my lord, the learned single judge, where I filed the appeal, my lord, there, my lord, they were on caveat. I had served the caveat, they appeared.
The estate officer's case.
Yes.
You are trying to, you are being evicted.
My lord, 15 days and they will push me out.
Proceed. I'll share. Unless
is
you
why.
say that you will not enforce that order.
My lord,
But
I'll grant you. Wait, sir.
sorry.
He might be having difficulty.
No,
Why? After all, he is appearing for an authority.
No, I am absolutely, my lord.
Tomorrow anything goes wrong.
No,
so
my lord,
he will have to
definitely. And
accept
this
it.
authority, I know.
prior to enforcement of the order.
You tell me, you want time?
My lord, yes, my lord. If it can be made returnable on Monday, that would be convenient, my lord. On till Monday, we can stay our hands. My lord, that's the instruction from the
Till
court.
Tuesday, you stay, you don't do anything.
My lord, the only difficulty is that there are dues also in respect
And that
of
is
the
why will I pass an order?
I'm ready.
and there is no subsisting lease also as on date, my lord. My lord, that's the whole difficulty.
He has challenged an order
Yes, my lord.
passed by the estate officer. Correct?
Yes.
Challenge in a statutory appeal. Please understand. He has a right to file an appeal.
Yes.
Now, in the interregnum, if he is dispossessed, what remains? But I will give you opportunity, come back. Come back with the calculation.
Well, I have the
No,
calculation.
not your calculation, ordinary calculation, because not your special calculation with regard to the special rates.
And let
Well, at one time,
Come
yes, sir,
back,
everything.
Come back with what would be the ordinary rate, that is the rate, market rate that is prevailing around.
Yes, your lordship.
Your compensation includes so many other things, sir.
No, your lordship.
That cannot be included.
my lord, that is why the estate officer could not even deal with it as to how and what amount it is.
No, market.
But he has
Market rates are, you have,
nothing. He has shown nothing.
where is that order? Where is that order?
My lord, kindly
Notice,
comes to the
notice,
last page. My lord, kindly comes to page 75.
9. 9.
79 ki kore holo? Oh, my lord, the impugned order, my lord.
Oh, no, yes, 75. Yes.
75, if your lordship sees. My lord, there are three parts to it. One is an eviction. Second paragraph is rent. And third is
Where is
damages.
that impugned order passed by the refusal to pass an
The
the
page 8.
My lord, page 80. My lord, we have got leave from your lordship to
but
file.
order has to be there.
My lord, order not yet. My lord, I've got a supplementary affidavit. Till date, they are not issuing the order.
It has not been uploaded.
It has not been uploaded. We have even yesterday we went up.
The typed copy that they have given, your lordship.
This morning also.
This morning also, my
Should
lord.
be knowing this.
Well, it,
You're on caveat.
we are aware, my lord.
No,
that
no, you're not disputing this.
No, your lordship, that's what my instructions is. The matter has been made returnable on the 24th of January. Well, that is my instruction.
24th of January.
January.
Yes, your lordship, 24th of January.
You don't do anything till 24th of January.
That is what I said. Fixes
You
it
don't lose
timeline.
a forum here because you unnecessarily don't lose a. It's better you go there.
My lord, I don't have any problem if the matter is remanded for consideration by
I'm
the
not
High Court.
remanding. I will not entertain the
For
matter
consideration, yes.
and record your submission. You will not do anything till the next date before the
My lord,
learned
in
trial court.
such a case, my lord, it will tantamount to an order of stay of the order of eviction, my lord. And your lordship, my lord, by virtue of the
No.
provisions.
Whatever your lordship.
By virtue of
Pandya,
the
I'm giving it.
provisions of section 96.
He is in difficulty.
I understand.
Since
It's an authority.
an
but he has
accommodation
some
has been
problems.
sought for. Since an accommodation.
But my
has
lord,
been sought for-
till Tuesday, my lord, let them.
Since an accommodation has been sought for, on behalf of the opposite party, how many opposite parties are there? On behalf of the,
My lord, one only, my
on
lord.
behalf of the opposite party, let this matter stand adjourned and appear under the same heading on মঙ্গলবার। সোমবার তো মঙ্গলবার অনেক হয়ে যাচ্ছে, এরকম হয় নাকি? 20 তারিখে রাখো, এত মামলা হয়ে যাচ্ছে, সোমবারই রাখো, মঙ্গলবার অনেক মামলা হয়ে যাবে, হচ্ছে ধরতে পারবো না।
My lord, if it can be made returnable tomorrow also, my lord.
No,
we are
tomorrow
ready
I have to take up other
to-
matters.
I'm so sorry.
কত?
My lord,
On Tuesday,
Sombar, Monday.
21st.
Monday, your lord. Monday.
So, what is your name, sir?
Snehashish Sen.
Mr. Sinha, learned advocate, appearing on behalf of the opposite party, however, submits that till the next date, till the next date, no steps shall be
Monday
taken.
হচ্ছে না Tuesday হচ্ছে?
21st.
Yes, kindly hear, sir. I'm recording your submission.
Yes,
Till the next date,
Yes.
no steps shall be taken by the respondents on the basis of the order, on the basis and in terms of the order dated
So, yes, sorry, my mistake.
26 December, order on the basis and in terms of the order number 74 dated 26 December 2024, passed by the estate officer Shaya Prasad Mukherjee Port, Kolkata, in proceedings number 1391, 1391 stroke R, 1391 stroke D of 2013.
One submission, my lord. Be
Till
recorded,
the
my
next
lord.
date, mean Monday.
My lord, only one submission on the next date, my lord. Kindly,
Independent of anything, I'll hear you.
my lord, only
Your whatever order is there,
one
whatever
submission be
concession you have given will not matter.
My lord, one submission. Kindly hears me out. My lord, kindly one submission that on the next date the condition to be imposed shall be determined by this honorable court.
Naturally, sir.
My lord, if that
That
can
is
be
very
recorded, the
usual what
calculation-
I do.
but the
My lord,
calculation-
Unless you want to go back there.
Please determining, my lord. My lord, kindly hears me out and then only, my lord.
My lord, there has to be a
My
direction
lord,
of
this
the
cannot
court.
be, but it was why, I will point out, my lord.
Right.
I will,
Following-
but why does it need to be go down today, my lord? Your lordship, consider.
No,
Kindly, your
following the ratio of the judgment delivered in the case of.
But I understand, my lord.
So
But it
today,
didn't go down as a premature that subject to conditions which I will pass
I
on
will
the
not recorded
Only
that. I
that,
know,
I'm
I
saying, but
understood.
But I've already told my clients.
Without that direction, you will not get 1 inch
I
here.
have already told my clients, my lord, but I said this no
Not
need to be recorded
only a
today.
one-liner
No,
recording,
my lord.
my lord, for the court,
My lord,
my
no,
lord,
no,
to
no.
bring forth the
Next.
calculation.
I have
Very
not granted
grateful.
any stay also.
So, my lord,
I
I
have
was
not
just
granted any stay.
Effectively, my lord,
It
we
will
are
be
not
taken
taking
up as a
such
clean slate on that date. It will be taken
my
up
lord,
as a
it's
clean
clear on
slate on
Monday or
that.
Tuesday. কবে রাখলেন?
Monday.
My lord, now there's a my lord,
মঙ্গলবার কতগুলো আছে? বললে তো অনেকগুলো আছে। তাহলে মঙ্গলবার, Tuesday in that
My
case.
lord, may it retain its position, your lordship, my lord, if that can be taken up. My lord,
my lord,
Why do you repeat this?
no, my
Sir,
lord,
you see, it's an upgraded motion. It is taken up every day. I am
But
not
I-
missed
I
one
am in-
day upgraded motion.
I'm in inconvenience on Tuesday, but still I said,
Authority,
take
my
it up.
Your junior will be there.
And I would have only, my lord, if I'm not there, my lord, with humility. But can you, if your lordship, my, they might request,
Upgraded motion, I will not.
but only takes it up on that day only, my lord.
Wednesday, then you want to tell me?
At 12 o'clock, if it could be, my lord.
No, I can't say this.
My lord, I'll try and take a pass
yeah.
if possible.
Because he is there, you have I understand, Mr.
But
There
it's
is-
only
there are
because I'm
so
a
many
partner, my lord. That is my problem.
I'll be Wednesday.
And if he agrees, my lord, I'll be very
Wednesday,
grateful.
Wednesday. Not the question of agreeing. If you have been difficult, then place it on Wednesday.
my lord, this day will be
Con-
22nd.
Yes, 22nd. Yes, Dakota, point list.
Very grateful. my lord.
My lord, and only that we
It
will
be
submitting
above
that
my
on
name.
instructions
Should be
and
listed above my name.
No, my lord, he's saying on instructions. On
I've
instructions.
submitted
Yes,
that.
obviously your instructing
My lord,
officer is standing in
they are
there.
all very, very about authorities, my lord. We
Yes,
feel very
yes.
scared.
So that is why I said that it will be difficult for him to pass.
That's why I would concede that if your lordship records this is submission on.
Who is your leader in this matter? Who is appearing?
My lord, Mr. Obrojit Mitra, Lane Senior Counsel is
Very
there,
well,
my lord.
Mr. Mitra will.
Grateful.
Yes,
Right.
yes. Opposite. Yes.
My lord, in respect to item number 7, my lord, it has been written in the notes, my lord, your lordship's list notes. 1 to 8 will be taken up first. Like in the head notes.
I'll take it up, not today. That is the matter will be taken up. It's not today, after the monthly. So it's
Okay,
unlikely.
Then my lord, kindly fix it Monday, my lord.
Not fix it, it will be there in the list.
The list, kindly, tomorrow it will come, my lord.
Tomorrow it will not be taken up. On Monday again.
On Monday. Grateful.
Because that matter requires some hearing. Your
My
matter.
lord, we are otherwise
I've
prepared.
checked up. So I thought that that matter, if it is taken up, it will be difficult.
No, my lord.
Other matter will be maybe
So
start.
Monday also I may not take up. I'll fix a date. So
My lord, as you lord said. Thank you.
yes, Mr. Chatterjee, your matter will be taken up.
On 9th January, your lordship was pleased to direct me to serve the learned advocate of the trial court as also the parties.
Nobody is appearing, Mr. Chatterjee.
I have served everybody.
What is the matter, Mr. Chatterjee? Now nothing can be
The
done.
matter is the plaintiff filed a suit before the court below. Your lordship kindly come to the plate.
Mr. Chatterjee, tell me something. You are aware of the position. You are aware of these proceedings.
What position?
The suit, you are aware of it.
Yes.
Your contention is before service of summons.
And another condition is also there.
Then what is recorded? That's what I'm saying. My Lord Justice.
Yes, that is for the interim purpose. My
Yeah,
submission
the
was
second
recorded.
submission. So,
Our main submission is this: in the suit, they prayed for something as ad interim measure. Ad interim application is prayed, not ad interim, final relief has been prayed. Ad interim order has to be prayed in aid of the final relief. Now your lordship kindly come to the plaint.
to your case, that is not neither here nor there. Only issue is local inspection.
Local inspection. In the plaint, I have asked for the surveyor, measurement of the land. What the advocate commissioner will do? May I put this question to myself? How she can identify what is my land, what is his land?
The court's prerogative to do so.
But if
The
the
discretion,
the
every
discretion-
drop of a hat, if the High Court interferes, it will be very difficult for the trial court to proceed.
Your lordship can appreciate. Discretion cannot be exercised
Yes.
beyond the scope of the plaint. Because it is plaint, I have prayed something.
Where is this application?
Yes. Huh? My lord, this copy was not with me at the present when the application was filed. Now it has certified copy has been obtained. This
Of-
is certified copy
Of
of order 39 rule 7 application.
Nilo.
আমাদের copy copy করে রাখা হবে।
Yeah, how you have communicated this order, Mr. Chatterjee? Communicated this order to the learned advocate?
Yes, the evidence service have filed.
Why they are not appearing, let me stay. They are not appearing, they are not interested. Because today I decide this issue in their absence. That is bothering me.
As your lordship please.
Because after all, they have filed the suit. Stay will affect them. So then they will come back. Yes, very well. Since despite service, the opposite parties are not represented. This was initially had come up under the heading extension of interim order.
No, returnable motion.
Write this order in their absence in a suit filed by them.
Yes, yes. No, I am not also asking that.
In a suit filed by them and set aside their application, prayer for local inspection, and they are not appearing in the court. Let the suit remain state. Not that you have not served, you have served, I've seen that repeatedly,
Repeated.
but very peculiar circumstances, Mr. Chatterjee.
Because, my lord, if I say to your lordship that this particular gentleman who has filed a suit, who has been evicted by the order of the Honorable Court, suppressing all these facts, he has filed this suit.
Let's see, let him come.
And we have filed an
If he's not interested, it will continue for some
we have
time.
filed an application to the next before the learned court below, indicating that this is the actual state of affairs. So this is the interim stage here. Main matter is pending there. We have filed the application there.
Yes, continue.
But I am for the opposite party. Well, here, the order passed on an application under Section 8 Arbitration Act is the order into the matter.
Yes.
And the arbitration clause is there in the agreement. And the fact of the case is this one in 2013, the parents of the petitioner made an development agreement with the opposite party hearing. And subsequently, as they further made one power of attorney. Both are raised at. Now, in 2014, my lord, the power of attorney was cancelled. That has been challenged by the opposite party. And in the suit filed by them, my lord, we made an application for arbitration. Since, my lord, the development agreement contains the development agreement, arbitration clause. So, the learned judge has considered that yes, it is the law, but still he has referred the article on reference to the arbitrator. He has said that the suit be continued and this application is dismissed. This is the
Kindly, if your lordship takes up the third page of the impugned order. Third page of the impugned order, middle portion, my lord. If your lordship kindly goes to the middle portion, my lord. In the instant suit before me, on careful perusal of the language of Article 14 of the development agreement, which contains the arbitration clause, as well as the Article 15 containing the jurisdiction clause, it prima facie appears that the parties to the agreement kept their options open in case of any dispute. While the first option, as per the arbitration clause, is to refer all disputes to the arbitration. The second part of Article 14 makes way for settlement of disputes that through civil or other
Arbitration Act, arbitration, শুনছো তো arbitration এর মামলা হচ্ছে, দাও ফলো করবে কোর্টে কি হচ্ছে, বইটা দেবে তো। Yes.
Yes. There, my lord, therefore it can be said that the intention of the parties at the time of execution of the development agreement containing the arbitration clause was not to specifically invoke the arbitration as means of settlement of dispute, but to select forum as per their choice for the said purpose. Because my respectful submission before your lordship is, at the time of execution of the agreement, it was the intention of the parties that they would not specifically always.
Where is section? Where is clause 14?
Page 53 of the revisional application, my lord.
Yes, yes.
Page 53, if your lordship kindly takes up.
Yes.
Article 14 and Article.
Yes, yes, sir. Sir, what is this? What is this clause, sir? What is this particular clause according to you? This line, in addition to arbitration, it may be settled through proceedings of civil court. So this line, in addition to that.
That is there, my lord. And after that, my lord, if Article 15, if your lordship takes up.
Sir, can I take it? Can I take it that this line starting from in case of any dispute, difference or question arising between the parties hereto with regard to this agreement, the same shall be referred to arbitration. Stop. One single line.
My lord,
can I accept it?
That is, my lord, that is there.
Can I accept the same to form a composite agreement between the parties? Can I accept it? I'm asking you, sir.
That is there, my lord.
If I can accept it
that is there, my lord.
to be a composite agreement between the parties, if it is an agreement in an agreement, the matter should be put to rest.
That is, my lord, but
matter should be put to rest.
The learned court below, after considering the aspects of the matter, has
Agree on
stated-
an arbitrator, come back, tell me, I'll appoint an arbitrator if you can agree. Or else I will refer these parties to arbitration. Matter ends there.
Then, my lord, your lordship may refer the parties to arbitration.
I will not. Ordinarily, I have then if I refer to, then you have to go with the Chief Justice. Because the parties would be referred to arbitration. What is the appointment procedure? Nothing provided. If you both of you can agree and tell me in the name of an arbitrator, I can, on the basis of that agreement between the parties, I can, matter will be resolved easier for you. It will be easier.
Whatever your lord, that I understand, lordship. that is
Because you
there.
see, I cannot
That-
ignore this.
That was my respectful submission, whatever your lordship.
The
said.
learned
That I
judge has gone little far because this is not a question of forum selection. The second line is there,
That is
but that does not denude the arbitrator from exercising jurisdiction or from the parties from invoking the arbitration clause, which is an independent agreement in itself.
that is true. ma'am. That
So
I-
you tell me, sir, you come back with an agreement, both of you. If you can agree, I can appoint an arbitrator, or else I will refer the disputes to arbitration. We will only complicate it because the suit stands disposed of.
That is true. Then
So your suit is there, you will be facing difficulty. Agree to and come back.
then I have to take instruction. ma'am, let me come back.
Agree and come back.
7 days time.
Yes. Since the parties would submit that there is a possibility to agree on the name of an arbitrator, agree on the composition of the arbitral tribunal,
Right.
and let this matter stand adjourned and appear under the same heading after ওই 23 তারিখের পরের সপ্তাহে on 27th I'm blessing. Appear নয়, be taken up for consideration on the same 27th. Or else I'll just set aside this order and refer the parties to arbitration if you cannot agree.
I will.
That will complicate because your suit will get
That is true. I will. I will.
goes
I
for a
will-
toss. You understand the situation
I will once take.
because that is one line which is an agreement between the parties. I cannot ignore it.
That
I
is
don't
true,
know.
my lord, but
Anyway, whatever is done by the land.
to submit my
start
lord,
us.
your lordship knows.
Both of you sit down together if you can. Because there is no other composition
Right.
indicated. The manner of appointment has also not been indicated. If you can agree very well,
As your
I'll record your submission and refer it to him.
grateful.
Yes.
Lord, this is my application. Your lordship lastly heard this matter, my lord, and extended the interim order till the end of the January. I have served notice upon the husband as well as the contesting advocate of the on behalf of the husband. This is my lord affidavit of service. Your lordship, my lord, to pass the order, or my lord extended the time as item number 8, my lord, your lordship, till the end of September.
What is the matter? Or
No, my lord, divorce filed by the husband in Nodia Navadvip, my lord, from my matrimonial parental house to this house, my lord, 110 kilometer, my lord. My lord, both the petitioner in my lord, service in the as group disturbed in the panchayat in Howrah, and husband also in Howrah, my lord, in another panchayat as a group.
Where do you reside?
My lord, I reside in at Belur, my lord.
Resided?
My lord, resided at Belur.
Belur.
Yes. And
You
this-
want a truck? This is under section 24.
Yes, no, my lord, only section 13. Section 13.
Section 13. What are you challenging then?
Divorce, my lord. I am seeking transfer only.
Say under section 24.
No, yes, yes.
What no, yes, you are saying?
No, main matter is, my lord, pending before the.
That is all right.
Yes,
Is it
yes.
an application
Section-
under section 24
Yes, yes.
of the Code of Civil Procedure 1908 for transfer?
My lord.
Where is your husband? You are the wife.
My lord, husband, my lord. My lord, Navadvip, Nodia.
Ali, where is he? He's not coming.
No, despite of serving 3 times, my lord, I have served. Husband as well as his advocate, concern. Or extended the time, my lord, so that I shall come back once again.
How have we served on the opposite party?
My lord, with the speed post, my lord. One is 20th December and another person is 26th December, means advocate.
Despite service, none appears on behalf of the Sir, serve on the advocate, intimate him, ask him to come. Otherwise, it is very difficult.
My lord,
Suit is stayed.
yes. Communicate to the husband as well as his contesting advocate also there. Despite of that.
Section 13, application has been filed. Maintenance you have applied? No.
No, I not. I working there, my lord.
Oh, you're working. That's all right. Yes, sir.
My lord, this is that
Yes, sir.
matter, my lord, your lordship may recall, my lord. The unfortunate father is before your lordship, my lord. In spite of visitation right granted by the trial court and by the high court, but till date, my lord, father is pending for the visitation of the son. My lord, your lordship may recall, my lord, I mentioned this matter, my lord. An act case was filed on behalf of the wife. The parties were living in New Delhi. My lord, the son was born, the son was taken away from the matrimonial home at the COVID times. And my lord, we've made an application before the court below to let me see my child. The visitation right was granted in presence of the mother. The mother created a scene, my lord.
Where is the mother? Where is the child now?
Child is with the mother, my lord.
Where?
My lord, she resides in near Tala, my lord, Shambhajar, my lord, area, my lord. Talapad, my lord. What happened, my lord? We challenged this order before this Honorable Justice Shampa Shorkar, my lord. Kindly see, this is absolutely a reason order directing the father should go. Modalities was made, my lord, before the.
Justice Shorkar has already passed an order.
Order, my lord, your lordship.
Yes, page.
Your lordship, can you see, my lord, the order of Justice Shampa Shorkar, page 179?
Yes. Well, they are not complying with this.
Not complying with this order, my lord. That is the reason.
No, thereafter they prefer an especially
no, SLP
no transfer petition.
Transfer petition, my lord, because my dissolution marriage was filed in the Saket Court, Delhi. My lord, that application was.
I see.
That was transferred to Alipur Court, my lord. That was Act 8 case.
She's not coming.
But she will not come, my lord. This is the reason, my lord. That is the reason, my lord.
Mr. Ghosh, tell me, One.
Well, do
How can I
something.
enforce this order?
Well, do something for the father, my lord.
No, you tell me how can I? This is not an ordinary litigant. Please understand.
Yes.
I cannot send the communicate this order to the through the officer in charge. I cannot do this.
Well, this has been done by the learned trial judge. Since she was not appearing, this, my lord, the OC Talab station was given sent to the.
How have we communicated this order?
Well, your lordship directed by speed post, and it was delivered.
You have checked it. You have checked it, Mr. Ghosh. You have
Yes.
checked it. You have checked it.
Yes.
It is served.
Served, delivered, my lord. Kindly do something for the father, my lord. He has come from Delhi, my lord. He wants to see his child, my lord. Your lordship, can you see? 23rd of January is the birthday of the child. 6 years. Well, your lordship on the last occasion directed, well, I should direct them to bring child to a place so that the father can enjoy the company of the child in the birthday. Well, do something for the father, my lord. डॉक्टर क्या बोल শচীদের নামটা লিখে
Despite service, এগুলো কি ডাকছো এত আজ? এগুলো কি? না এটা non-appears dismiss করবে। Non-appears in support of the divisional application. No accommodation has been fought for. In view thereof, let this application be dismissed. না এলে কি করবে বলো? দেখা যাবে।
না না কত খারাপ।
I appear for the opposite party, man. I'm led by Mr. Joydeep Kaur and Mr. Saptangshu Basu. Because if Mr. Saptangshu Basu is sick, my lord, I'm just praying an accommodation for the day only, my lord. If he lost-
They means these are returnable motions.
My lord, only on
I
Monday.
take on Thursdays only. And exceptionally on different dates, Mr. Mitros.
Because
You see, the list it is.
This may come back to your lordship's mind, my lord. This relates to, my lord, the school. I do not want.
Yes.
Mr. Basu has given an undertaking on the last occasion, which has been recorded, my lord. So there is urgency because our client is also not able to utilize the
Kindly
property.
any day, my lord.
That Thursday only. Then it goes to the next monthly list in that case. No. On 6th.
No, 30th it may possibly. I do not.
30th is there.
Or before
30th. List on. In view of since an accommodation has been sought for on behalf of the opposite party, let this matter be taken up for consideration under the same heading on 30th. Mr. Mitra, you're opposing? No. No. I'm just asserting. No. I just heard commotion behind your back. So that is the reason I went back.
The status quo should be preserved. That is.
Yes, it's already recorded.
Till the next date of hearing.
Till the next date of hearing. That is difficult.
The interim order can continue.
Sir, undertaking recorded.
The parties are directed to maintain status quo till the next date of hearing. Maintain status quo till the next date of hearing. I'm passing a order of status quo. Have you understood that? Do you let the undertaking be continued?
Yes, that has to.
The undertaking given by Mr. Basu. Mr. Basu.
No, senior advocate that কি হয়? কি senior advocate? Adjournment এ যে senior advocate কি হয়?
On instructions on 16 December 2024. Shall continue. It is submitted on behalf of the opposite party that the undertaking given by Mr. Basu. And when an adjournment was sought for on the ground of ill health of a learned advocate, there was a lot of commotion behind.
Because that was for other reasons. Commotion because we did not believe that he was sick.
Very unusual, I tell you. No, very unusual for him not to come to court also.
He called me yesterday for another matter and said that he was
under the weather.
I have seen him for the past about 35 to 40 years. I touch wood, I haven't seen him.
কোটে দেখবেন তুই কোটে দেখ
আমি দেখেছি এমনি এতে দেখি touch wood never seen him.
Yes.
Touch wood.
দেখো পয়েন্টটা দেখো নামটা জেনে নাও জিজ্ঞেস করো দেখো Sir, kindly give your appearance, kindly.
The same heading, my lord.
Yes, sorry, I've not disturbed anything. It will be also called on that date. Yes.
They point to
Sir Dotto, everyone is interested to hear out the motions. When it comes to hearing of matters, it is very difficult. No, not Mr. Mitra. Mr. Mitra is here. But when it comes to hearing matters, you see, nobody is there.
That's right, it appears. And this was the scenario all through.
Also, yes.
Also. When the matter is appearing in the motion, everybody shows urgency and interest. And there are
You will be astonished to see the mentioning on Monday.
Yes.
I accept the fact that people may have urgency, so I hear everyone. But the time taken to hear out is around 1.5 hours to 2 hours. But not on the first day of the monthly list. I hear it so that I can fix it for the entire month.
Tries to adjust, my lord.
It's very difficult with 1600 matters in the list.
Huge.
Let us proceed. Yes, yes.
My lord, this matter, the point of law which is involved is whether the court has power to extend the time under Section 5 of the Limitation Act.
Oh, this is monthly. Oh, those are gone. Motion. Very.
But it was there yesterday, my lord.
No, it is all right.
Whether the court has power to extend the time under Section 5 in an application filed under Section 7.1 and 7.2 of the 7.1 of the
7.2 court has the power.
7.1 has power to extend the time, particularly when it is on the ground of an advocate who has himself said that he had lost the papers and that is why he could not file on time. This is the whole, whether the trial judge has held, relying on Supreme Court judgment, that the court does not have any power to extend the time. So that is why my application was
Under 7.1.
Under 7.1.
both files. 7.1, 7.2.
7.2. 7.1 is a combined application.
No, two separate applications.
Two separate applications, 7.1 and 7.2. Both the applications were dismissed on that.
7.2 does not apply.
If you also kindly look at the improved order, this is one-page order, my lord, kindly. The given petition contemplates to condone the delay of 81 days in preferring the application under Section 7.1 and 2 both of the Act. In course of hearing, the defendant submitted that senior counsel misplaced the brief for which the given applications could not be filed in time, and as such, there has been a delay of 81 days. There has been a delay of 81 days, which is placed to continue. On the other hand, counsel from the plaintiff stated Section 5 has no application in respect of 7.1 and 2, pointing out a decision of honorable court reported in so and so, but this is equivalent to 2019 Supreme Court cases.
2019?
2019 volume 10 SCC 660. After going through the given petition and other materials placed before it, it appears as under. The application made by the defendant substantially contains all the above necessary to sustain his prayer for extension of time to prefer 7.1 and 7.2 petitions of the Act for condonation of delay in making such application. It is necessary for such reason to look the provisions, particularly 7 of the West Bengal Premises Tenancy Act, Section 7 mandates all areas of rent calculated and with interest as provided. Clause B in subsection 1 mandates the payment for deposit to be made with 1 month services. The Act of 1997 mandates the deposit of rent, or where there is dispute regarding quantum of deposit of admitted rent along with application for determination of rent must be made by the tenant with time specified. This is in relation to the suit filed for divorce. Where compliance with the deposit mandate which enable the tenant to seek the protection provided and the ratio of the decision reported in so and so is squarely applicable. But I could not consider this 2022-1 ICC because I could not get them. Upon a careful consideration of the material on record, it appears that the contention of tenant that he could not take proper steps for his learned counsel lost the deed, for which he came up with an application for tolerance of delay in filing application under section 7(1) and 2 cannot be accepted, as court can condone the default only when the statute confers such a power on the court and not in that view of the matter. Now, can you see the provision? Yes, my lord has got the book. Yes, yes. ওইগুলো এখানে দিয়ে দাও সব কটা বই এখানে মানে 26(7)(1) on a suit being instituted by the landlord for eviction on any of the grounds referred in 6, the tenant shall, subject to the provision of subsection 2 of this section, pay to the landlord or deposit with the civil judge all arrears of rent calculated at the rate at which it was last paid and up to the end of the month previous to that, in which the payment is made together with the interest at the rate of 10% per annum. Such payment or deposit shall be made within 1 month of the service of summons on the tenant, or where he appears in the suit without the summons being served upon him within 1 month. So 1 month is the time limit to deposit under section 7(1). My application is a combined application 7(1) and 7(2).
You said separate application.
Separate, but court has considered both the applications
Together, yes.
Now, 7(2). If in any suit referred to in subsection 1, there is any dispute as to the amount of the rent payable by the tenant shall within the time specified in that subsection deposit with the civil judge the amount admitted by him to be due from him, together with an application for determination of the rent payable. No such deposit shall be accepted unless it is accompanied by an application for determination of the rent payable. On receipt of the application, the civil judge shall, having regard to the rate at which rent was last paid and the period for which default may have been made by the tenant, make as soon as possible within the period not exceeding 1 year, and order specifying the amount, if any, due from the tenant, and thereupon the tenant shall within 1 month of the date of such order pay to the landlord the amount so, not the provision. Kindly, the two provisions minor sense. Provision number 1, provided that having regard to the circumstances of the case, my lord kindly says that having regard to the circumstances of the case, an extension of time may be granted by the civil judge only once, and the period of such extension shall not exceed 2 months. So therefore, the provision for extension is there in the statute itself. The Supreme Court judgment which has been referred to, the Supreme Court judgment has specifically dealt with the subsection 1, not the 7(2), because the 7(2) itself contains the provision for extension. But apart from that, before I go into this aspect of the matter, Lordship knows the law where the statute specifically bars, or restricts, the court does not have any power to extend that time. For example, Companies Act, Arbitration Act, section 34, 120 days and not thereafter. The word is included. That means the Arbitration Act has been restricted of challenging an arbitration award not beyond 120 days. Therefore, in any case, section 5 cannot be applicable in that case. But there are a number of judgments, Lordships.
Exclusion of section 4 to 29 of the Limitation Act, having regard to section 27 of this act.
Limitation Act.
When a special statute or local usage or custom language is such,
Yes,
provides for a different period of limitation than the one provided in the subs, a little different.
language is better. So therefore, my lord, what I want to submit, my lord, Supreme Court judgment, I am going to refer to.
No, you will show me. Sir, I said anything, you will show me, but only one thing before you proceed. There are coordinate bench judgments of this court. And I am bound by the coordinate bench judgments of this court. You show me the coordinate bench judgment and how can I overcome that? You have to show me those coordinate bench judgments.
That's compulsory.
No, not one. There are multiple judgments. There is a division bench judgment also. That see today there is admittedly there is a delay.
Delay. Like delay.
7-1 delay.
Delay was.
Once 7-1 delay is there, 7-2 fails.
But 7-1 has not restricted.
7-2 fails.
7-1 says it has to be deposited within 1.
Come to 7-3. You'll subject to.
Come to 7-3.
Yes.
If the tenant fails to deposit or pay any amount referred in subsection 1.
But stop. 2 is or. 2 is not conjunctive, disjunctive. So or means 1. So there matter ends.
No.
You show me the judgment if you want to. If you otherwise, I will decide it. I'll place it on Monday. Come back with the judgments if you want to, for me to take a different view, because my coordinate bench has taken a view on this. All languages odd. You did not comply with one. So matter ends there, Mr. Dotto. Subject to correction, whatever you say. No, I'm not. I think Mr. An advocate is there to argue a matter and the court will hear the matter. You come back with any authorities. If you want this court to take a different view, I will hear you. But you show me the authorities on the subject. I'll bring it. I'll share it to you on Monday. Monday, not today only. Not today means not this week. Effective tomorrow, I don't take up this matter. You see, your difficulty is 1.
Not 2. Because 2 itself.
You cannot overcome 1. Anyway, I'm not saying. Sir, you will consider whether or not to overcome 1. I'm not saying. But I'm just indicating.
This also goes, my mind also goes.
I know.
That I cannot.
No, naturally, sir. So you come back, consider and come back. Monday. List on Monday. Heard Mr. Mitro, learned advocate, learned senior advocate, representing the petitioner. This is on Monday. That's senior. And it's senior.
Level 1 is of specific 30 days time has not made it any restriction that it cannot be done beyond that.
If it is read coupled. Sir, the golden rule of interpretation that we have learned from you is unless the statute provides.
Specifically not.
No, provides. See, you see how to consider a provision is mandatory or directory. If it provides for a consequence, then it becomes mandatory.
That is what Supreme Court has said.
So we have learned from you on these lines. So here, Rule 3 says it is consequence is there. So it becomes mandatory. Anyway, come back on Monday.
Was the defendant in the suit? I filed. No, I prayed for revisional. I prayed for. I.
Yes.
This matter has become infructuous.
Since the learned advocate representing the
I am acting on behalf of the Bali municipality, my lord. Kindly
My
grant
lord.
the petitioner to serve a
My
copy.
lord, the advocate on record for the petition has not come to court due to personal inconvenience. My lord, kindly make it not today.
what is the matter? You don't know.
Copy was served, my lord, for the Bali municipality in this matter.
Since since an accommodation has been sought for on behalf of the petitioner. Let this matter go out of the list. You are not there. Your name, how can I record? There is no direction for service on you.
My lord, but the Bali municipality is the party. I am appearing with them.
I can't accept your appearance now. Let them move the matter when it comes. Cease for accommodation matter is out of list.
My lord, I am appealing for the petitioner in this matter. My lord, this revisional application arises out of a matrimonial suit. I have a prayer for expeditious disposal, my lord. My lord, time and again the respondent have sought for time seeking adjournment that was granted. There was resolution from the local bar. My lord, the last order for framing of issues was passed sometime in early 2023.
Maintenance application is pending.
My lord?
Any maintenance application is pending.
Nothing. No interlocutory application is pending before the court.
Any maintenance application has been filed. You are for the wife.
My lord, I am for the petitioner wife. No application. I have instructions. No applications are pending. My lord, I am also instructed. There's a high possibility that this matter may be mediated and settled. If my lord pleases to send it to the mediation center of this honorable court, there's a chance that this matter might be settled.
Praying for expeditious disposal of the matrimonial suit
No difficulty, sir. I can't
My lord,
take it up.
this is to fix a
April.
date.
April month. April returnable motion will be called on. Expected it will be called on. You see, today also there is returnable motion. It has been called on. Nobody is there.
Much obliged, my lord.
None appears in support of the revisional application. No accommodation has been paid for in view thereof. Dismissed. I'm dismissed. Sim.
Proceed with this matter, I'm happy with the petitioner. That amount title suit is pending in before the civil judge senior division third court at Howrah. I'm paying for early expeditious disposal.
Refiled.
155 kindly make it actually.
File an application for restoration. You don't want 155. You are appearing. Adjournment you're seeking. Go out, Kurado. Yes.
Pass over. Council.
Sorry, madam. I dismissed the matter. Now, at your instance, since you are seeking an adjournment, I have directed to go out. Yes, call the next matter. I dismiss the matter. Then you file an application for recall. Sorry, you were not there. Anyway, call the next matter. Sorry, matter. Different matter is going on. You cannot. Yes. Yes, madam.
Titles. 156. I'm
Going on.
applying
Yes.
that.
Yes.
It's going on.
156 is going.
That's it.
Yes. Yes. Continue.
Let's say one title suit is pending in the Learned Civil Judge Senior Division Third Court at Howrah, and I'm paying for earlier disposal.
Yes. Any interim application is pending.
Let's say,
Here, injunction application is pending, madam.
let's say in this matter injunction and next date is there is a fixed for adding to injunction next date.
When is the next date?
Next date is 4th June.
4th June?
4th June for adding to injunction extension.
Which 4th June? 4th June of?
2025. Let's see.
Where do I get it? 4th June 2025?
Let's see. Next date is fixed for
4th or 14th June?
4th June.
Are you certain, madam?
Let's see.
The present application has been filed interiorly praying for expeditious disposal of the title suit number 420 of 2021 pending before the court of the learned Dismissed, non-appeal. Dismissed.
I am before your lordship with an innocuous prayer, my lord, because, my lord, as far as order is concerned, it is my folly, my lord, that I did not follow the proper procedure. My lord, I'll just give a 1 minute of my lord. What happened is, a particular probate case had been filed before the learned district judge. My lord. There, I ought to have filed a caveat and an affidavit to the support of my objection, if I am a third party intervener. Now, my lord, I did not do that. I, under wrong perception, filed my objection, but the nomenclature was under Order 1, Rule 10, for me to be added as party, my lord, which is not the procedure, my lord, because as soon as I lodge a caveat and an affidavit there to my lord, then, my lord, I become entitled to make that particular probate proceeding a contentious cause. And then there is an embargo. But, my lord, what has happened, my lord, while disposing of my application, the learned judge has come to this finding that I have no right. Now, my lord, that will adversely affect.
He has allowed the application on order 110.
Oh, no, my lord, rejected. It was my, it cannot be allowed, my lord.
Come to the order.
617 has allowed. Order 6, Rule 7, amendment has been allowed.
Rejected, yes.
Amendment has been allowed. What happened, my lord? Now, what is the factual matter? Why I have a very good case, my lord? There was a particular gentleman who died issueless. He had actually adopted 2 children, not by
a caveatable interest.
Yes, I have a caveat. Because the property was initially, it was given under a will to me in 2011, executed in Rajasthan. The Rajasthan laws do not have any such provision that it is mandatory to get a probate. There are a lot of judgments starting from 1954 AIR. I did not file a probate proceeding with regard to the property in Rajasthan. I am in possession. I am enjoying this property. Now, my lord, the testator, while he was residing in Calcutta, he was not in good health, mental and physical. So, a particular will, both the wills are unregistered. A particular will was executed by the so-called adopted daughter, who was a witness to the first will, which was in my favor with regard to Rajasthan property. In the second will, there is no state. He has said all the movable and immovable properties. The will says. Now, this particular lady who has not been given the right to the will, but his father and biological father and brother has been bequeathed the entire property, including that of Rajasthan, which has been bequeathed to me by way of the first will. And the second will writes specifically that my first will is removed.
So you admit the subsequent will is the second will?
I don't admit. I say that's a forged one. So therefore, it's a forged one. It was obtained. It does not even. But then for that, I have a caveatable interest.
How?
So, my lord, what I'm
How you have a caveatable interest?
My lord, because the will by way of amendment in the probate, in the letter, in the assets, affidavit of assets, they have brought the property which already has been bequeathed to me by the first will, and I'm enjoying that property in Rajasthan.
If there is a subsequent will,
no,
the latter will prevail.
My lord will kindly appreciate if today that will prevail. That will prevail, my lord. But then, my lord, here my lord will kindly appreciate one particular aspect. Do I have a caveat?
You are a legatee under a previous will.
Yes, my lord. Now, my lord, do I
from the Indian Succession Act that you are a capital interest? Say that okay, Indian Succession Act. Indian Succession Act.
My lord, I have. My lord, one particular point is to be taken into consideration by my lord, is that none of them are first-class legal heirs. None of them are first-class legal heirs. The person concerned is
yes.
Now, my lord, I am on, my lord, 284. Caveats against grant of probate or administration. Lordship has got it. Caveats against the grant of probate or administration may be lodged with the district judge or a district delegate. Immediately on any caveat being lodged by the district delegate, he shall send copy thereof to the district judge. Immediately on the caveat being entered with the district judge, a copy thereof shall be given to the district delegate, if any, within whose jurisdiction it is alleged to have the deceased has fixed place of abode at the time of death, and any other judge or district delegate to whom it appears to the district judge expedient to transmit the same. Form of caveat, my lord, that is in Schedule 5. Then, after entry of caveat, no proceedings taken on petition until after notice to the caveator.
Where is your caveat?
My lord, that is what I am on before, my lord. At the very outset.
Established that we have a caveatable right.
My lord, I am entitled to file a caveat and then it will be established on contentious cause.
Gone, lawyers, long
No,
back.
that is what I am wanting, my lord. But an application was filed under Order 1, Rule 10. It should have been filed. So, my lord, what I am humbly submitting is.
When did you come to know of this application?
My lord, we have stated in our petition.
You show me that you have a caveatable interest, first of all. I am not satisfied. Show me any authorities that a legatee on a previous will be entitled to have a caveatable.
My lord, I shall show my lord authority.
Yes,
And my lord, if
Monday. Not today.
So it has fallen from my that I have to come, that I have caveatable.
Yeah, unless why will I grant you that?
My lord,
if you show me you have a caveatability, I'll
yes,
consider it.
I will. I'm great.
Next.
My lord.
Same position. It will be. Ask your juniors to be here because.
No, my lord. Yesterday, my lord, my juniors are here, my lord. I was on my legs.
Because you see, if nobody moves the matter, then I either direct it to go out,
my lord,
or if nobody is, I dismiss it.
My lord, my
because
chamber
so
is
many
very
matters are pending, I cannot just hold on to the matters.
My lord, we are very cautious. My lord, I was on my legs before, my lord. Yes. My lord, I came running to do this matter.
Ensure that some of your juniors get
My lord,
ready in
they
the
will
matter so they can start.
My lord, they will.
No.
My lord, I am for the petitioner. My lord, this arises out of a suit for declaration and permanent injunction where I am a defendant. The suit is, the plaintiff has filed a suit claiming that the A schedule property, the plaintiff is the owner, B schedule property is the defendant is the owner, and he has defined one A1 schedule property, which he says that the plaintiff is the owner. In the defense case, I say it's my property. A1 is the disputed portion. They take out an application under Order 26, Rule 9 for local investigation. The commissioner's report was filed. I filed an objection to it, and the report has been accepted. My lord, that brings me before your lordship. My lord, kindly, my lord, my point is that the fixed point that was taken by the learned commissioner is that a mud house in the
Commissioner was appointed. Where is the warrant of commission? Where is that?
Lord, that has not been annexed.
You have not annexed that, sir. What he will do, and you want the court to consider.
I understand, my lord, that has not been annexed. Huh? Kindly gives me a liberty to file a supplementary affidavit.
Can you come on Monday? No.
My lord, because it's from Durgapur, so I need to get in touch with the learned lord advocate there.
Since an accommodation has been sought for on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of March.
A liberty may be granted to file a supplementary affidavit.
As prayed for, leave is granted to the petitioner to file supplementary affidavit. The writ of commission has to be disclosed.
I understand. It has been stated in that gravely, but it is still not with me.
So what will the court understand?
I can understand.
What he is required to do?
My lord, I'm appealing for the petition or praying for not today, my lord.
Go out.
Great.
Yes. Go out. Yes. Yes.
No, 161 I'm for the applicant, my lord. The expeditious hearing of this application for expeditious hearing of injunction application pending for learned Civil Judge Junior Division, Kakdeep, title suit number 214 of 2020, my lord. And the defendant in the suit below, my lord.
Instant divisional application. ওই আগেরটা একটা প্যারাগ্রাফ মিস হয়েছে, দুটো প্যারাগ্রাফ বলে দিচ্ছি তোমাকে, এটাতে বুঝতে পারবে তাহলে। Instant divisional application has been filed inter alia praying for expeditious disposal of the injunction application filed in connection with title suit number 214 of 2020.
And for the opposite party husband.
You are on caveat. এই নাম দেবে না কিন্তু opposite party. None appears, no accommodation has been sought for. In view thereof, let this divisional application be dismissed for default. Because they had not been admitted. Once it is admitted, then only.
One difficulty is there, my lord, challenging the same order. I have preferred another civil revisional application, my lord, that was item number 90. In a previous week, my lord, that matter has been tagged with this application. Now, this application has been dismissed for default, but my application is still alive, my lord.
Oh, very well. Move your application. Move your application.
My application is for reducing.
Take it down.
My application is for reducing of alimony pendent my lord.
You want to place it or you don't want? You want an adjournment? Tell me, madam.
Yes, adjournment, my lord.
92 অর্ডারটা আছে 92 তে আছে ঠিক আছে শালি শুধু none appears on in support of the aforesaid revisional application in CO ওর নামটা দেবে CO 1648 of 2024. No accommodation has also been paid for. In view thereof, let the aforesaid revisional application stand dismissed. First of the applicant, the petitioner in CO, what is the number?
CO number 1452 of 2024.
CO 1452 of 2024 is however represented. She prays for an accommodation. She represented. She submits that the revisional application, aforesaid revisional application, she submits that the above revisional application was tagged with this matter by order dated. Was it tagged, madam? Tell me.
Monday.
Was it tagged? Any order was passed tagging?
Well, I'm supplying it, my lord. Yes, my lord.
Unless you supply, that will not be uploaded.
Yes,
Tagged along with this matter. She, however, seeks prays for an accommodation. ওই তো order আছে he, however, pays for an accommodation. He, however, pays for an accommodation. Tags with this matter by order dated 13 January. Now, the said revisional application has been directed to be heard along with this matter by order dated 13 January 2025. First of all, since an accommodation has been sought for on behalf of the petitioner in CO 1452 of 2024, let the same stand adjourned. Send the same go out of the list. Whatever.
Item number 163.
Wife is the petitioner before your lordship. This revisional application is directed against refusal and order for recalling of a witness. Let me place the background of this case. Husband
No,
filed a
why you seek recall and then you go back?
lordship.
You first tell me why you seek recall and then you go back.
Yes, I seek recall because of the fact, lordship, there is a change of advocate, and the erstwhile advocate did not hand over the entire brief to the present advocate, so he could not go through the entire evidence. Some important questions were left aside, but this is not the reason why the court has refused to allow this application. Suit was filed by the husband.
At what stage the recall was filed?
After evidence. Just after closing of the evidence of PW1, I filed this application. I'm giving you the date, lordship. What has happened? The suit was filed. In the suit for divorce, lordship, under 13(1)(2), I filed an application under section 24 for alimony pendentiality. An amount was granted. Husband, being aggrieved by that amount, came up before this honorable court. First revisional application, that amount was reduced. It went back. Husband did not pay that amount. I filed an application. Court directed to pay that amount with arrears. Husband again became aggrieved. Again came before this honorable court. Justice Arijit Banerjee rejected that application. It went down. Again, I filed an application. Who rejected? Justice Arijit Banerjee. While sitting singly. Again, it went back. Again, I filed an application for stay of the suit because unless you pay the entire amount, the suit cannot proceed. That was allowed. Again, the husband came up before this honorable court. Justice Sanjeev Banerjee categorically directed unless and until this amount is paid, the suit will not proceed. Thereafter, the amount was paid, 7 lakhs and odd. This is the reason behind the delay of the proceeding of the suit. It is of the fault of the husband. Now, after that amount was paid, thereafter I filed an application for enhancement. That was rejected on the ground, since by the observation of this honorable court, that amount has been paid, so therefore there will be no enhancement. This is the first time I came up before this honorable court, and Justice Hinonmay Bhattacharya disposed of the matter. Your lordship will kindly come to page 62 once.
Challenge here.
No, why? Why? Because some observations are there. I'll just read the concluding part. For the reasons aforesaid, the impugned order stands aside. The learned trial court is directed to consider the application for enhancement of the alimony afresh on merits in the light of the observations contained herein before, and to dispose of the said application as expeditiously as possible, but preferably within a period of 8 weeks from the receipt of the order copy, without granting any unnecessary adjournments in either of the parties. Parties will also be at liberty to produce material documents in support of their respective contentions in connection with the prayer for enhancement. Since the suit has reached the stage of evidence, all further proceedings in connection with the matrimonial suit before the trial court shall remain stayed till the disposal of the enhancement applications. Once the arrears, if any, as per the decision of the enhancement application are liquidated, and the husband is not at default of payment of the current alimony, it will open to the parties, opposite party hearing, to pursue the matrimonial before the learned trial court. Now, this order was passed, lordship, on 4th of April 2024, and I filed the application for recalling of the PW1 on 5th of February 2024 in the main matrimonial suit. This is in respect of Miss case. This order was challenging a Miss case order. Now your lordship will kindly come to the impugned order.
No, when did you file your chief?
Chief was filed by the husband.
You did not file anything. Recall, you are seeking recall of his witness.
Yes, because
his witness.
Yes, because I have to put some questions to the husband.
Where
because
is
it is
your
a matrimonial suit.
Where are the questions?
Where are these questions? Lordship, will
It is not your witness. It is the defendant's witness or opposite party's witness you want to cross-examine.
Yes, yes.
Where are the questions?
Questions are not with me, but the application is there.
Law is very clear. You have to put in the questions. What you will ask.
No.
It is no open-ended, sir.
No. Order 18, Rule 70, your lordship will kindly consider.
Show me, yes. Yes, sir. This is decided by several judgments of the Supreme Court as well as our court. Yes, sir.
Yes. Court may recall and examine witness. The court may, at any stage of the suit,
Yes, yes.
recall any witness who has been examined and may, subject to the law of evidence for the
Yes.
time being enforced, put such questions to him as the court thinks fit.
Court, not you. This is power of the court, not you.
I filed an application under 151 for recalling of the witness on the basis of
So
this.
therefore, the court will test out what questions you want to put. Why it may happen, Mr. Rai? I tell you, I'll give you illustrations. The plaintiff's witness is in the box. And in course of examination, the plaintiff's witness has said many things. Thereafter, your witness goes in the box and says many things. In course of cross-examination, certain points are said by your witness. So therefore, it becomes necessary for you to cross-examine the plaintiff witness on those points.
My
And
evidence,
therefore, you have to identify the points.
my evidence,
Your
has,
case is different.
my
Here
evidence has
you
not
want to-
started.
The court will ascertain whether you want to fill in a lacuna of your case by way of re-examination of cross-examination. Why?
So
Not
there is
permitted.
no question of filling up lacuna. Your lordship will, the reason of the rejection. Your lord.
There are judgments on this, Mr.
Yes, yes, lordship.
Kim, show me the judgment. Otherwise, I will place it on another day and fix it, finish it off.
Judgment.
Yes, yes, yes.
I have not bought the judgment because,
Well,
of the
you have
facts.
not identified. You have not yet identified Mr. Rai.
No, why I am calling for the witness? That is my application. If your lordship will kindly consider the application first.
You have not identified what are the questions.
Because I could not, because I did not got the copy of the brief.
And that is your headache, your agent.
No,
Your
it's a-
agent.
It
It
is
is
a
your
chain brief.
agent. Mr. Wright is your agent
Yes, true.
who has misplaced the brief, not their agent.
No. But the reason why, lordship?
This cannot be you cannot delay the suit on this ground.
No, no, there is no. That is why I placed the history of the case.
And May 2024, no mentioning, nothing, matter has remained. The suit has not proceeded.
No, that
Suit
enhancement.
has not proceeded.
Why not proceeded? Because of the fault of the husband.
Now, from May 2024, the
No,
suit
no,
has proceeded.
that enhancement application is being heard.
Now the enhancement application is being heard. 8 weeks is not over.
8 weeks is over. I think. No, that is there. That is why I have placed the entire history of the case. If your lordship will go to the filing date and why this suit is pending for such a long time, that is the only reason why I have placed those matters. And if your lordship, so finds
This is
lordship,
your application.
yes, lordship. That is at page 49. Third, that during cross-examination, PW1 learned advocate, Mr. Sushanto, was not supplied the earlier evidence, both chief as well as cross-examination. As a result, he could not be able to go through the earlier examination of the witness.
Yes, he has relied on this judgment, 2011 SCC 275. Our court has passed a detailed judgment on this. When, under what circumstances you can recall witness and what you have to identify in your
Then if your lordship so finds this application is not up to the, on following the judgment of this honorable court, give me the liberty to file an
the
application.
matter ends.
No.
Matter will end, sir.
No, why that reason of delay only has been
I will
quoted.
give reasons why the matter should come to an end.
Lordship will kindly see what the reason of delay. It has been quoted by the
Monday, come on, Monday.
Lordship. I will be out
Tuesday,
of station.
Thursday, when you want it.
Thursday.
No, Thursday is holiday. Thursday is a holiday.
Wednesday.
28, I'll take it up.
Allah.
28. Heard Mr. Rai, learned advocate, appearing for the petitioner. List this matter under the heading returnable motion in the daily supplementary list on 29th January. দেখো তো 29th January কি আছে?
I will come back with the judgments.
But I have just now come to learn that the opposite party has expired. So I have to take steps, my lord, Kindly allow me to come back.
Mr. Banerjee, learned advocate, appearing in support of the aforesaid application, would submit that he has come to learn with regard to the factum of death of the opposite party very recently. Having regard to such submissions made in court today, let this matter go out of the list.
With liberty to mention.
Naturally, you take no mention. You have to take.
No, possibly it is not beyond 90 days, so I have to pray for
You know what to
setting
do.
aside.
You know what to do.
I'll have to mention before.
No liberty is necessary. You have to file.
I'll file then come back with the application. The application is
I've recorded recently.
recently. That saved me.
You said so. I've recorded your submission. And the other side, you have to serve on the other side, but
I'll serve the application. I'll file the application and serve
no. Oh, it's abated already.
Can I? Yes. No, in the trial court.
But it has not been admitted. It has not been admitted.
Can I serve a copy of the application? Also?
Have you filed application before the trial court?
No, it is their appeal. I am the respondent there. My eviction decree in my favor, that has
So
been,
that has abated.
that has appeal.
The appeal has abated. Nothing remains here.
If the appeal has abated, no steps have been taken there, that is my instruction. But in any case, I have to take steps
Because
here.
you see,
get an order.
miscellaneous appeal of
This is eviction decree.
eviction degree. So appeal. So if that is so,
This is
then
against an order where unconditional stay has been granted without any occupational charge, saying that the rent controller will.
now the appeal has abated. So therefore, this application has become infructuous, Mr. Banerjee.
Unless they can take steps there, then this.
When they take steps, then only you come. Otherwise, till such time, there is no necessity. They go now.
Inquire there. If it is recorded, it is abated, then I can execute that.
Because today this has not been admitted. So there is not a necessity to serve. But question is,
Depending on the proceeding in the trial.
yes. If they have not taken any steps, matter ends there.
If they, tomorrow they take steps, because I have to challenge this. Otherwise, I will not get any occupational.
The decree into execution, they will take steps. Prior thereto, they will not. So,
Prior thereto, they will not come.
yes, Mr. Yes, sir.
Lord, the defendant tenant is a petitioner before my lord, in a suit for eviction. And the subject matter of challenge is, Lord, my application for undertaking essential repairs at my own cost, having been rejected after considering the learned advocate commissioner's report, which fortifies that in fact the premises is in shabby condition, dilapidated condition.
Where is the order?
Lord, the order, Lord, the original of it, order number 52 dated 7th March 2024. May I read it to your lordships, my lord?
I got it. You are not making payment of rent. You are not making payment of rent.
My first issue is that in a suit for eviction, essential repairs, Lord, cannot be aligned to payment or non-payment of rent. Cannot be done. That is not, it's like a character of a person. When is it relevant? I am a defaulter.
Tell me, are you paying rent or not?
I am. I have annexed documents.
You making payment of rent?
Yes. I have annexed documents anterior, 6 months anterior to the date when I filed the application. It is, I have annexed here.
I'll get an undertaking from you that you are paying rent.
It is annexed. Documents, challans are annexed in this petition.
Having the present divisional application has been filed, challenging the order dated order number 52 dated 7th March 2024, passed in ejectment suit number 39 of 2014, whereby the petitioner's application praying for essential repairs filed under section 151 of the Code of Civil Procedure has been rejected. 151, sir?
Lord, it is not said under any section, but it is 151.
Achha, dorkar nahi. Likho na, tale application for essential repairs has been rejected. Mr. Chaturvedi, learned senior advocate, appearing in support of the aforesaid revisional application, by drawing attention to the order input, would submit that although the petitioners, although the necessity to carry out repairs is supported by the report of the advocate commissioner, the learned judge has dismissed such application by proceeding on the premise that the petitioner has failed to pay continuous rent, Mr. He, however, submits that the aforesaid finding passed by the aforesaid finding of the learned judge is incorrect, and that the petitioners are regularly making payment of rent. First up, regularly making payment of rent.
And such finding cannot be a ground of
No,
rejection
that is different. I will not.
at this moment.
Very simple matter.
Yes, I understand.
Pay, I'll allow. It supports the commissioner's report.
Yes.
Not allow, I'll send it back with a direction, because he will have to, the court has to allow.
Yes.
So having regard thereto, I am of the view that the officer revisional application is required to be heard. Let a copy of the revisional application be served on the opposite party, lest this matter. Then you take your chance as and when it comes. Let us, because now there are several motions, several applications under returnable motion. Let us see how it goes.
Lord, I shall. If required, Lord, I shall mention.
Maybe will be taken up. Small points in the revisional application, only accepting for few matters, sir. The issue is very small.
Yes.
May not take so long. May be taken up.
May not.
Because everything is decided here.
Yes.
The order speaks for itself. Let us not go. If you can demonstrate you are paying rent, I'll on the next occasion. Now, today I cannot allow.
No, I am only
on the next occasion. I've recorded your submission.
Yes.
I'm not gone into this because I'm sure what you're saying is supported by.
I'm extremely grateful, my lord is trusting.
Yes, naturally, sir. So therefore, sir, tomorrow when you show me that, I will allow the application and send it back, because everything is decided here. Subject to hearing the other side if they have any other point to raise.
My lord. And deep level. February monthly list and until April stay.
I have not granted any stay. What stay? What stay? Their suit. I'll allow their application for repair. What stay, sir? What will you do with the stay? Tell me.
The only thing is, until unless the suit is stayed, they are not interested.
If they do not come on the next date, I'll allow it. Or I'll direct you. I'll grant interim order if necessary.
Lord, I was only beseeching your lordship. The state does not any benefit in my favor as of today.
It does not.
But my lord,
no difficulty is it's a eviction suit, and you are only entitled to make repairs. That I will allow.
Yes.
If required, if necessary, after hearing them. But you can't stall hearing. They're two different aspects, Mr.
The only thing is that it can, my lord, ensure their presence. I'm only.
No, that is different. Later, why you presume they will not come? Let us see.
I'm grateful to my lord.
Yes.
I deeply obliged.
Next. I only think you should be ready to make payment now. That is the only hitch. I will remove that. You are occupying the property. You have to make payment.
And I'm running a school.
Yeah, running a school. You have to make payment. You can't say that you will not make.
I am making.
Therefore, I've recorded your submission. You'll continue to make payment till disposal of the suit. Matter ends. You'll do your repairs.
I'm deeply.
But that has to be sanctioned by that trial court. I cannot allow.
Yes, my lord cannot. My lord
in revisional application, I cannot. You also understand this is a difficulty.
Then the learned trial court says the nature and character will change. My schedule says, what am I going to do? The
essential repairs, it's recorded. Essential repair has to be allowed.
Yes.
To what extent that the court will consider?
Trial court will decide.
But that is not the basis for which it has been rejected. Rejection basis is different.
No, there are two reasons. One is that rent not paid, and second, it will change the nature and character.
That will, to the extent it does not change the nature and character.
Yes.
Essential repairs.
Yes. Only that much.
I
have to ensure the safety of the children and the staff. I have to ensure the.
I have to hear them. They are on that.
Yes. I'm deeply obliged. I'm grateful to you.
Call the next matter. Who's appearing for the Nekoni? Yes, Mr. None appears, no accommodation sought for in either of the.
lord, my application for expeditious disposal of an opposition filed before the trademark registry. This is his regard to a, yes, my lord, that is, my lord, one issue.
You go before file an application separately. Take back this application.
I will kindly then transfer, not take back, my lord. Lordship will release
Why
it.
will I transfer?
My lordship will release the matter and I'll mention before the appropriate division, because now the IP division has been set up.
IP is a division bench? No.
No, my lord. There's a single bench, but the IPR division has been set up. Now, my lord, this has been filed prior to the IP division coming into force.
You take it back, you file afresh. There is no limitation involved in this.
Indeed, my lord, but the
You know,
whole
you
thing
take
is,
it
my lord,
back.
my lord, the whole thing is that I had filed it prior to the IP division coming in, my lord. All I'm beseeching, my lord, is to release it, and I'll
You file it there immediately. They all create complications.
My lord, perhaps there may be some difficulty because the client is in Ranchi. That's the thing.
I have to consider this, whether, because the scope of 227 is different, sir.
But I have earlier orders also.
Yes.
Lordship will kindly have a look at it.
Yes, sure. Yes, sure.
Lordship will kindly pardon me. I have marked.
No, I'm not going to allow it simply settle like this.
It's an opposition hearing pending since 2023. I am registering my mark, Samriddhi Rajaji. The opposite party number 2 has filed an opposition. All the pleadings have been completed. Now the hearing is not taking place. All I am seeking for is expeditious disposal of the opposition filed by the opposite party number 2. Well, similar orders have been passed earlier as well, my lord.
The court has allowed this application.
Yes, my lord, the court has allowed.
The court has not transferred this.
No, my lord, this is so far as the your lordship is on
and this was done on March before
the. My lord, that's what I'm saying, my lord. The IP division has come in 2025, or rather at the end of
if you invite the court to go there, the court has to consider, because the court does not lose jurisdiction under Article 227. It only sends the matter there. You are entitled to take back.
Lordship will kindly transfer it, my lord. The party.
No, I got transfer is a judicial order. Then I have to consider the matter. I'll place it under the hearing and consider it.
Whatever, my lord, I have whatever I had. There's nothing
Easier process is, if you want to take it back, I'll grant you that. Take instructions and come back. That's the easier process.
Because my lord, my submission is the same. This application was filed prior to the IP division coming in, my lord. Thereafter, the IP division has come in. I understand, my lord, there's a huge confusion which is going around, because I have faced this similar issue in another matter, my lord. I have faced
before this court.
Before this court, my lord. If your lordship recalls the Rekit Benkaiser matter.
Yes.
Mr. S.N. Mukherjee and Mr. Devnath Ghosh were appearing. There was a huge issue at that point of time. I understand. But that was being filed post the IP division coming in. This application was filed prior to.
I did not grant that leave.
No, but in that matter, your lordship had granted that leave, because the nomenclature will also change in accordance with the IP rules.
Because the rules, I have rules here with you.
I'm sorry, my lord, I'm not carrying it.
Rules does require transfer. Therefore, I have to examine to what extent your application and to what extent that can be transferred. Like, very well, come on.
There's a huge confusion regarding this, my lord.
No, you want a transfer is a judicial order on this. You want a judicial order, therefore I have to consider this.
I'll be very honest with my lord. My lord, the taking back and refiling may be a little difficult. That's all. Maybe a little difficult. However, if it has fallen from,
then I'll place it under the head. I'll hear it out on this, whether to what extent, whether this requires transfer or not on this issue.
Very well, whichever way.
Because you want the court to pass a judicial order on this. I have passed a judicial order.
Because the only thing is, my lord, previous the IP division, similar orders have already been passed so far as expeditious disposal is concerned. That's all I'm at.
No,
before
the IP is not IP division.
No, that's what I'm saying. Before the IP division was there. That's all I'm saying. That's why I handed up the order.
No, I cannot allow this today. Because you see, today the IP division is there.
Yes. It is.
So your remedy lies before the IP division.
Yes, my lord, it does. So your lordship will kindly then transfer. Because that, I think, my lord, I am not carrying the rules. May I come back tomorrow with the rules? Then, my lord, it will be much more.
27th.
My lord, it will be under the same.
I say it will be there in the list. 27th. You come back on 27, it will be there in the list.
Very well. Very well. No issue.
Another matter is there, I'll be placing that on 27th also and on the same issue.
Very well.
ওই মামলাটা আছে না, একটা রুলসটা দিয়েছে, 27 তারিখে দিয়ে দাও, একসঙ্গে ট্যাগ করে নিয়ে নেবো। আপগ্রেডেড, ওকে ছেলেটাকে ডাকো না, ছেলেটাকে ডেকে আপগ্রেড করো, একই দিনে নেবো। দাঁড়িয়ে আছে ওদের লম্বা হচ্ছে, এই থাকবে। Yours is on 27th.
Very well.
If it does not come up, yours matter, whatever is order is passed, I'll pass it.
Well, I'm so grateful. So grateful. What was that?
27.
Great.
Same position.
Very.
So effectively first matter in the monthly list.
The next matter is also similar matter. May I seek a small indulgence?
Yes,
for that?
yes.
A very small indulgence. Item 109 was dismissed for default matter. Another, again, a same matter.
Not mentioning. Yes.
I understand.
Take out, that is over. Yes, call the next matter.
Great.
এই দুটো পাসওয়ার্ড নয়, এই দুটো 27 তারিখে নেবো। তোমার ভেতরে লিখে রাখো, অর্ডার পাস করছি না, সেই দিনই শুনে সেদিন আইদের ট্রান্সফার করে দেবো, বটে যা করার করে দেবো। হ্যাঁ। এটাও সেম একই অর্ডার, এটা 160। ওইটাও রেখেছি তো, একসঙ্গে করে দেবো। ওইটাও আনাও ছেলেটাকে দিয়ে গেল রুলসটা, ও মেনশন করবে সোমবার, 27 তারিখে মনে করে দিয়ে দেবে।
My lord, in 169, my lord, I am for the petitioner. This is, my lord, against the, my lord, inadequate quantum of the, my lord, alimony pendency right. And, my lord, the amount is, my lord, the 10,000 for the petitioner and 9,000, my lord, for the minor child. And, my lord, so far the opposite party number husband is concerned, my lord, she is the, my lord, the employed under the central government, under the, my lord, the department Shahar Surakha Ball. And at present, my lord, he draws salary about, my lord, the 1 lakh.
You did not file any, what do you call the affidavit of asset?
Affidavit? Yes, my lord, I have filed the application under section 24.
Affidavit asset. Affidavit of asset, you did not file?
Affidavit of?
Asset.
Asset of the the opposite party?
Yes.
No, my lord, I have not filed, my lord, the.
You did not file your income, expenditure, you did not
My lord,
file.
I am the housewife, my lord, I have.
So,
my lord, I
law
have.
is very clear. The judgment delivered in the case of Neha, very clear.
Then,
This
my lord,
order cannot be sustained. I'll set aside this order. There is no finding by the learned judge. That is why I can't find. I'm just asking you.
Then, my lord, give me liberty, my lord, to file the affidavit of my asset, my lord, then.
Yes. So how much you are getting?
My lord, 19,000.
What is his salary?
My lord, when the I filed,
75,000.
no, my lord, that is.
The salary slip is there.
No, that is in the year, my lord, 2021. My lord, 2021, my lord, that is in the 2021. But now, my lord, the about, my lord, more 1 lakh.
From where do I get it? Is 2021?
My lord, of course, my lord.
Where is that salary slip?
I have no salary slip.
And you did not annex anything.
My lord,
He has disclosed his
my
salary
lord,
slip.
now, my lord, I have no connection with my husband, my lord, so I cannot get the my lord, salary slip. My lord, at that relevant time, my lord, 2021, what I
Sir,
had.
you have connection with your client and the matter in the suit.
No,
Are you connected
no,
with your
my
client?
lord, so far the my lord, petitioner and the my lord, the
Sir, are you
husband is
connected with your client?
Yes, yes.
You are connected with your client?
Yes.
In the trial court, this document was filed. Where is that document? Since the petitioner is not ready in the matter, list this matter in the month list of February under the heading motion group 1. New motion 1. Group 1 is also in Mamla.
Can it be, my lord, on the, my lord, the after, my lord, my lord, the
March
22nd or my lord, in the meantime, I shall get everything, my lord.
It is new motion 1, it will be taken up.
Yes, or make it on 27 or 28, my lord, or 21st, my lord, on any day.
Sorry. Double. None appears, no accommodation has been sought for. In view thereof, let this revisional application be dismissed for the court. Yes. Admitted, you are on caveat.
My junior got the caveat.
Are you-
Correction, blood, your lordship. May I check and
No, I'll check it out.
It's long.
No caveat. None appears, no accommodation, dismissed. Naam diyo na. Unless you are in caveat, you can. Unless, because not admitted, sir. Once it is dismissed with your name, it has to be restored with you. Yes. Let's call the next matter.
Your Lordship, I am appearing for the petitioner led by Mr.
Hello. Your Lordship, I'm on this matter. Yesterday, Your Lordship remembers item number 144 and 172, I said will be taken together.
Yes, continue.
Yes. So what happened here was, I am the auction purchaser. This is a matter coming from the DRA, 2 orders of the DRAT. I am the auction purchaser. Now, in the DRT, the owner of the borrower filed an action to set aside the sale. That was dismissed. At that stage, he made an appeal. The appeal, Your Lordship knows, is the precondition is there, a pre-deposit amount which has to be put in. Now, the question was the money around 70 lakhs which they had received for the sale consideration which I had paid could be seen as the pre-deposit amount. On 14th of September, the DRAT gave an order saying that yes, that the sale consideration which has been received by the bank, because that is over 50%.
What is the explanation for the delay in filing the application, Mr. Sinha? The order is the 14th of September 2022 and not 2024.
No, Your Lordship, that's why. Just hear me out. I will tell you why it is like that. I'll explain that. Everything is explained. Your Lordship, just this is a sequence of events.
Which order?
I am against 3 orders, Your Lordship. I'll just come to that. Let me just.
If you seek to challenge 2022 order, I will not permit you to challenge at this stage.
No, may I just, okay, may I just indicate, Your Lordship? May I just indicate what is happening because of that order? Now, what happened is, immediately, so Your Lordship, what happens is, that was passed in September 2022. On 6th, before another hearing could take place in the appeal, on 6th or 5th of January 2023, the Supreme Court came out with an order saying that no, the sale consideration cannot be taken into account for pre-deposit. It cannot be because you are challenging the sale. If somebody challenges the sale, then the pre-deposit amount cannot be taken into consideration.
So then what happens is, Your Lordship, we make an application. We make an application before the DRAT. Now, if Your Lordship takes up this matter first, there are two grounds on which it gets dismissed. One is obviously there was a mix-up in the typographical affidavit portion.
Challenging the sale.
Sorry?
Who is challenging the sale?
The owner, the borrower, that person is challenging the sale. I am the auction purchaser. I am saying that the pre-deposit amount as per the Supreme Court judgment cannot be understood to be the money that I have paid. I have paid. If they are challenging the sale, the Supreme Court is very clear on this point. What the DRAT holds is they dismiss my application sometime in 2023 on two grounds. What are those two grounds? One is that there is a mismatch in the affidavit portion. There is a mistake. There was a typographical mistake. That is one. But there is another thing what Your Lordship will just come to page 2 of the order. Page 2, the first paragraph. It holds that a judgment passed by a Supreme Court is only prospective in nature. It is not retrospective, which is completely, Your Lordship, against what the Supreme Court itself says. In myriad of judgments, that unless specified, the judgment goes back to the root. All judgments, because they are declaring the law.
Only. On interpretation only.
On interpretation, but the Supreme Court, I have, Your Lordship, 3 judgments.
See, now, when a court interprets a particular act, unless the judgment is made prospective, it is retrospective.
That is correct, Your Lordship. That is exactly
my interpretation.
No, that is correct. The Supreme Court says, Your Lordship, but not this. Here it's a blanket statement which says a judgment is always prospective in nature.
22, we are a long way thereafter. 2024, Mr. Sinha.
Your Lordship, may I just indicate what happened? This is in 2023. This order comes out in 2023. Because there was a problem in that affidavit portion, there was a direction, and there was a notary and all these problems happened. There was a problem. So that was taken and we filed, and this, Your Lordship, must also be considered. Nobody was present actually when this order was passed on merits. The counsel was not present. The counsel was present, nobody was present. So we made a recall application. This was dismissed, which was dismissed again. That is the part of the 144. That's why I said the two, Your Lordship, two civil revisions are analogous, one after the other. This is going on a chain of events. So it's not only of 2022, it goes to 2024. Then what happens is, the court then says, and that why haven't you challenged the 2023 order in the High Court? As you have not challenged, I will not change my decision. Now, Your Lordship, I am at a bind. Where do I go? I am showing Supreme Court judgments which say that no, it cannot be prospective. It has to be retrospective unless it is declared to be prospective. I'm showing, I have the judgments, Your Lordship. My junior is carrying all the judgments there. My problem is today is that if
not going to go into that detail, what happened 2 years back, unless you explain. Your explanation is not appropriate. You sought for recall of that order. So you might for me, look, for instance, you are by your recall, you are seeking a review of the order. You sought for review. Explain your conduct. Simply that you fight for a recall review of the order, knowing fully well review may not be maintainable.
No. Your Lordship, what I tell you, you
have become wiser, Mr. Sinha. Now you want to challenge this after 2 years, 3 years practically. Why will this, when will you file the application?
No, Your Lordship, may I just indicate?
Yes. 2 years. After 2 years.
Your Lordship, I have not challenged. Your Lordship, see, cannot be 2 years. Supreme Court order came out in 2023, January. I thereafter filed this application. I filed my application after the Supreme Court judgment came about. And then it was dismissed sometime in the middle of 2023.
Supreme Court did not interpret anything there. No provision of law was interpreted, sir.
Your Lordship, it was. Supreme Court said, see, Your Lordship, the court held. Your Lordship, may I just indicate?
Yes.
14th of September, the DRAT held, in not my case, myriad of judgments, cases, that for the purpose of pre-deposit, the money consideration obtained by the bank as a sale of the property will be considered. And there is no requirement of further payment for the purpose of pre-deposit. Supreme Court on the very same issue after 3-4 months in January 2023 says, no, it cannot be considered. Appeal is not maintainable. If the appeal is with respect to you are challenging the sale. If the borrower is challenging the sale of the property, then the money obtained in the sale cannot be.
You see, that order, that issue cannot be reopened today. That order was already passed when there was no Supreme Court judgment.
No, that is true. But the thing is, no,
Mr. Sinha, that cannot be reopened. I'll pass.
No, Your Lordship, may I just indicate the Siddha judgment, Your Lordship, may I just show the judgments on this point?
Then you want your matter because there is nothing to pass any interim order in your matter. It's only final hearing. Nothing, no question of any interim order, no scope. You see, after 2 years, you can't say that go
Your Lordship, it is not 2 years. Your Lordship, the last order which has been passed.
Say this DRT suit. Even on your own showing, Mr. Sinha, 2023, that order was passed and the revisional application was filed after a year thereafter.
No, Your Lordship, may I just indicate my order for recalling was dismissed on April 2024. April 2024. My recalling application was dismissed on April 2024.
Point of when your recalling application is dismissed, I find that your 7 July 2023. I will not go into that. The main order was passed much prior to that.
May I indicate, Your Lordship? Your Lordship, we come to the point. We come to the item number 144 order. Please.
It for hearing. I'll finish it off. Mr. Sinha, I'll place it for hearing and finish it off. It is better.
But Your Lordship, the matter is being kept for final hearing.
Whatever happens, the matter.
No, Your Lordship, may at least give us
nothing. You can't have an expeditious disposal now. Since you have this court has
taken. Your Lordship, I have filed it in my matter gets dismissed in 2024.
No urgency on your part. You have shown no urgency. You did
may I indicate only one thing, Your Lordship. April 2024, the matter, my application gets dismissed only on one ground. One ground is that.
Mr. Sinha, I'll hear you. I'm not dismissing your matter today. I'll fix it and hear you. I cannot hear you now. It's a motion. Your matter has to be heard as a returnable motion. You want to argue point of law? I'll hear you on this.
But if Your Lordship, there is no stay before this matter is taken up for
hearing. There was any stay. There never was any stay.
But if Your Lordship, there is no stay. My only thing is, if there is no stay, Your Lordship.
No, nothing.
At least Your Lordship keeps a short date for hearing it's a point of law.
Yeah, that I'll do.
Yes.
Having heard Mr. challenging the orders dated 14 September 2022 and 7 July 2023 passed by the Debts Recovery Appellate Tribunal Kolkata. Both are Debt Recovery Appellate Kolkata in appeal number.
Your Lordship, in appeal number 100 of 2022.
Where do I get it, Mr. Sinha?
In the order itself, Your Lordship, in the order on top of
page.
Your Lordship, this is
oh no, just 6.
This civil division is the last page. You lack.
In appeal number.
Your Lordship,
it says die number 75.
No, Your Lordship, absolutely in the last page, the order impugned orders are annexed.
No, the 11-page order. Where is the number of appeal, Mr. Sinha?
It's not an 11-page order, Your Lordship. 11-page order is the first order, Your Lordship. The next order, Your Lordship will see, which is not internally.
Appeal number 100 of 20. Both orders you have challenged, Mr. Sinha.
Yes. I have challenged 3 orders, Your Lordship. The last order is of 2024. That is why I am delayed.
Arising out of SA 539 of 2019. The instant revisional application has been filed. Having heard Mr. Sinha, learned advocate appealing for the petition, I have the view that the opposite revisional application is required to be heard as a returnable motion. Now, having heard Mr. Sinha, learned advocate representing, Mr. Sinha, learned senior advocate representing the petitioner, let this matter stand at and appear as a returnable motion in the month list of March.
Your Lordship will not make it monthly list. Your Lordship just gives a date on which hearing is done. Otherwise, this will again languish. Your Lordship will keep, it is a matter for hearing.
Returnable motion, return not here. You want a hearing and I'll put it contested application. That is the best you can get, Mr. Sinha. Returnable motion, I'll take it up. Ordinarily, I'm taking up returnable motions. Ordinarily.
Ordinarily, that is why I'm saying it is, if it is whichever, your Lordship, all I'm saying is whichever takes the shortest time, if it is a contested motion, if it by giving them notice.
February is already filled up. I cannot take up. I've fixed a cap on how many returnable motions I can take up. So I'm fixing it in March, it will be taken up. Let us see what happens.
Your Lordship, my only concern is that then, my entire, the appeal would be disposed of. The way this is going, the appeal would be disposed of before that. Your Lordship, may I just suggest one thing? If your Lordship is pleased, just dismiss these applications, give a direction to the DRAT to hear the application, to hear it out. Because what the DRAT is saying,
my conscience, I have to be clear in my conscience, Mr. Sinha, that the judgment delivered by the Supreme Court would, in the facts of this case, require the tribunal to revisit their order, which you are trying to do. I understand, Mr. Sinha. What you are trying is, I'll test it out.
May I only indicate?
I will hear you on that, because it's a point of law, Mr. Sinha. Whether the tribunal will be required to revisit the order on the basis of the judgment delivered by the Honorable Supreme Court. Because you that it is on the basis the judge. I could have done it today, but it will take, the motions are stuck. So I am doing it. These are on Thursdays. These matters will be taken up on Thursday.
Then your Lordship keeps my matter on top, because otherwise, your Lordship, I am telling you what
only on Thursdays. The returnable motions will only be taken up on Thursdays. There are not many. Mr. Sinha. Let us see how it goes.
No, only your Lordship.
I have understood your contention. Your contention is, Mr. Sinha, that by reasons of the subsequent judgment delivered by the Supreme Court, the tribunal would be required to revisit its orders because it can no longer treat that amount. Which, yes, I understood.
Not only that, all I was seeking is
if you succeed, I will allow your application here itself.
144.
I do not need to send back the matter to the tribunal once again. Question of law.
I understand that, but the reason is my 144, the item number 144, the application there was dismissed on the ground that I have not got a stay order from the High Court. And that is what.
A different issue. Let us see what happens. You did not get a stay order for 2 years. Don't insist for any stay.
No, I didn't need to. There was all I'm
on the contrary, this matter will be disposed of, whichever way it goes. It will be better for both the bank as also for you.
No, bank is with me, your Lordship. The bank is supporting me because I am the auction purchaser. The person I have been out of pocket, your Lordship.
Directed to the opposite party as of now. I have not directed to, sir.
Very well. All I'm saying is, your Lordship, what has happened now is I am out of pocket. Imagine what my plight is for the last 5 years. For 5 years or 6 years, I am out of pocket.
Challenge that order earlier. Who stopped you from challenging that order 2022?
I did. Unfortunately, I filed an application there only, and that got dismissed by saying that the law is prospective, taking a completely contrary view than what the Supreme Court says.
That is the issue, Mr. Sinha. That has to be considered by the court. It is not
very well. Very well. I will.
Sinha, you see, understand, it is not so simple that the court can immediately allow your application or grant a stay. It is a question of law that you are pleading that has to be considered by the court. This court will hear you. I have understood your point on this.
Very well. Very well, your Lordship.
No. Because otherwise, these applications will be at your
Your Lordship, at least a line could be added. This point will be considered by court. At least
that is why I have taken up.
No, this point of will be that can be added at least.
I'll be content.
No, please, your Lordship. Otherwise,
the issue raised by you will be considered by the court. I'll record that. The issue raised by Mr. Sinha would be considered by this court on the returnable. Yes. Yes, Mr. Sinha, I'll consider. You have placed this case, I'll consider your points on the returnable.
Now for the petitioner lordship, led by Mr. Gautam Dey. Lordship, this matter is related to expeditious disposal of the suit on 2nd November 20.
How many injunction applications are pending, madam?
One injunction application is pending before the Barrackput Court Complex.
And you want suit to be disposed of. How can a learned judge take up the matter when an injunction application is pending? Can the matter be transferred to the peremptory board when an injunction application is pending, madam?
Previous occasion, lordship, this matter was taken up before the Shialda Court Complex, but after that, the matter was transferred from Shialda Court Complex to Barrackput Court Complex. After that, the COVID period has started.
When was the injunction application filed?
2nd November 2017. 2nd of November 2017.
Who are you appearing for?
I'm for the plaintiff and petition.
Do you want the injunction application to be disposed of?
Yes, lordship.
And the present revisional application has been filed. Inter alia praying for
consider paragraph 12. Once
Paragraph will not do, not such a sketchy application.
that order already annexed.
Where is that order?
No, no, not for the REIT and not for the MAT, Lordship. That
Entire
was already
development
disposed of and
petition is also
REIT
rejected.
petition already disposed of. Thereafter, the MAT was filed and that order also passed and the
To
MAT
produce
also
all relevant orders in file all relevant orders or produce all relevant orders related to the aforesaid matter.
Great.
When the matter is taken up. Yes, call the next matter.
I have to file the supplementary evidence.
Produce.
Only the order. Great.
Application for expeditious disposal for disposal of my review application, ma'am.
Trademark 27th. আরেকটা ডাকো 27 ট্রেডমার্ক 27 ওই দিন আছে আরেকটা ডাকো চট করে It's a trademark matter. I might transfer it also to the intellectual. This is an intellectual property matter, so I might transfer it. Yes,
175.
this will be the last matter for the day.
I am for the petitioner. The father of the petitioner, the petitioner, the father of the petitioner, since this is made, he was the plaintiff along with other plaintiffs. Since the expired mallet, the petitioner and the other legal heirs are incorporated as a plaintiff before the planet trial.
What are you challenging, madam?
I am challenging the order, mallet. Kindly come. The last page of my application, mallet, there is the order dated 1st of March 2024. Mallet,
Application for
mallet, there is an application seeking mallet, for examination of PW1. Which
recall,
mallet, which was initially the deceased father of the petitioner number 1 in the present.
You are seeking recall of your own witness.
Yes, mallet, the witness of my father. Mallet.
Why?
Mallet, the dispute is this. Mallet, the PW1.
During cross-examination, did he make any statement?
No, mallet. No, nothing, mallet. Only the exhibit marked.
Not marked.
Was inadvertent, mallet. It was tendered. The document was tendered.
Was
but
not
it
marked
was
as exhibit.
Marked exhibit. Only that part I was seeking, mallet. But kindly come to my application. Mallet, at page 16, annexure P2.
Only exhibit marking.
Only exhibit.
Ashma. Challenging the order down. Suit till the end of July 2025 or until further order, whichever is earlier. Or yes,
And the obliged.
I'm seeking an accommodation of item number 189.
Not called on, not called on. Monday again. These matters, Monday.
No, my lord, I'm not well. I seek it for Tuesday, my lord.
ওইটাকে দিয়ে দাও 189 টাকে টিউসডে করে দিও মনে রেখো
I'll be getting it.
মনে করে রেখো না মনে থাকবে না ডিসমিস হয়ে যাবে লিখে রাখো ইয়েস তা শুনুন ডাকুন উঠে যাবো
I'm grateful, my lord.
Deeply obliged.
Item number 1, 3, 4, 5.
The short passover.
6, 7, 8,